Lordship, may I be
regarding appellate side, I beg your lordship to the order 41 matter to be listed.
Your Lordship, may I be permitted to mention
All
this
order
matter
41 give.
Your Lordship,
Great.
Your Lordship, no, Order 41, Rule 11, upgradation.
Yes. Upgradation. Matter is called on nobody. Twice the entire list was called. Upgrade. Where you were. Anyhow, it will be taken up. Don't worry.
Item 1 of today's application. It's an application. Urgency is my lord, 2nd May is date.
Just give. But we will be taking application the whole week. This. Don't worry. Yes.
12th of April, my lord, I filed the affidavit of service, my lord, pursuant to an order of paper publication. However, my lord, this matter has gone out of the list.
It will appear if
Permit to mention, Your Lordship, for upgradation, Your Lordship,
application or order 41.
Order 41.
Where you were last week, then entire list was called. Just wait. We'll take up the order 40. Don't worry.
Your Lordship, may I have your Lord's kind leave to mention a matter? It is appearing as item number 26 in today's list, Your Lordship. Lordship, there has been a certain misunderstanding in between the matters that were called, because our matter was inserted later. If Your Lordship gives me 30 seconds, I'll indicate to Your Lordship. This matter was mentioned on Friday, but Your Lordships had observed that this matter was called on for hearing. And Your Lordship's court officers also said that. But Your Lordship, my item number is, my FMAT number is 119. Your Lordship's list was called on till the 19th of April, till the Friday. It was called on till FMAT 90. Therefore, Your Lordship's list said that from FMAT 120 onwards, we'll call it on Wednesday. Because on Monday and Tuesday, Your Lordship was taking some other matters. Because we had mentioned the matter, my item number, FMAT 119, falling between 90 and 120, was actually inserted in the list on Monday, Your Lordship. Which is why our matter was never called.
Yes, we will take up the matter serially. Don't worry.
Your Lordship, may I kindly hand over the mentioning slip?
Not necessary. It is already appearing in the
Yes,
list.
it is appearing as item number 26. Your
We'll take up the order 41 one day.
Grateful, Your Lordship.
May I be permitted, my lord, for inclusion, my lord, on CAN application?
Give application.
Lordship,
Yes, Tapu.
Lordship, may I permit you to mentioning the matter of correction? I have a submission, my lord. I have a mentioning. Item FMA 80 number 369 of 2022. The records are lying in court number 21, learned Lordship. Supratim Bhattacharya released the matter, and the matter is supposed to be here in magistrate courts.
Permit to correction of order, correction of order.
My lord, may I hand over the execution petition as is pending and the list of dates in connection with GA number 1 of 2023 filed in connection with the instant appeal.
First thing is you have to argue what was disposed of by the trial court by passing the impugned order.
The impugned order was passed ex parte on 2nd March 2023.
Ex parte.
Ex parte. I was not heard, and without any.
Just 1 minute. Let me first understand. The impugned order, which is annexed to the memorandum of appeal, indicates that this judgment was delivered on 2nd of March. I do not find any application, but only the EC number, that's an execution case number. So execution case has been disposed of,
Execution case appears to have been disposed of.
appears to have been disposed of. So your first point is that it was ex parte,
Expert.
but it appears that your name is also appearing as defendant number 1.
1B. Now, my lord, I
So
have
we are hearing this.
appeal along with the application. Now, my lord, this impugned order was passed ex parte because I have already noted in my letter dated 5/1/2023 at page number 148 of my application, first application, that is annexed. And without any judicial order, it was made part heard, listed as part heard. And the case was disposed of thereafter. That order also I have annexed in the application. Now, my lord, the issue was that I was supposed to be heard out. My list of dates was allowed to be filed, which was already on record, pages 148. But I was not heard. Now, I wanted to submit before the learned executing court that several orders were passed by the learned executing court after filing of the same on February 2014. Now, annexing a purported copy of a decree reflecting that defendant number 2 is alive. Simultaneously, the heirs of the defendant number 2 is contesting the case. Now, already when decree was filed, purportedly annexed to the execution, my first point was that simultaneously there cannot be defendant number 2 and the heirs of the defendant number 2 on record, because in fact defendant number 2 was brought on record on 4th September 2019 for the first time, when original defendant number 2 died on 31st May 2008. The Hon'ble Court directed for substitution that was stated in para number 17 at page number 23 of the execution petition that I shall refer to your lordship. Already I have annexed the said order of the Hon'ble Court in my application. Now, my lord, my first point would be, if your lordship kindly comes to the execution petition, Xerox copy what I have annexed, which has not been considered by the learned executing court. These points were there, several orders were passed, and those were not considered. Now, execution petition copy I have handed over by. Now, lordship, kindly come to the tabular statement first, after the first page. That is the first page. This tabular statement indicates in the third column that decree dated 19 December 2007 sought to be executed. No appeal was preferred. And thereafter, my lord, the columns are there. This decree for partition. And lordship, kindly find the last second column, it starts with the names of the parties and the execution prayed for by the then plaintiff, original plaintiff. That continued till next page. Now, if your lordship kindly comes to first, in the suit on 8th March 2005, the Hon'ble Court declared the equal 1/3 share of the original parties. Advocate commissioner, learned advocate commissioner was appointed. She was directed to engage valuer surveyor. Valuer surveyor was engaged. Report was directed to be filed before the court. The incomplete report was filed. And my lord, the several points were raised before the learned advocate commissioner. Those were the learned commissioner herself indicated in her report that order required from the Hon'ble Court. That was not done by the parties. However, my lord, the valuer surveyor filed report wherein several illegal, rather the point of law submitted by the valuer surveyor that this scheme of partition has not been made in accordance with law at page number 53 of his report, valuer surveyor's own report. Be that as it may. Now, Based on this incomplete valuer surveyor's report and the incomplete report of the commissioner, who were never discharged till date, although she is no more with us, but no new advocate commissioner was appointed. No new advocate commissioner was appointed, but in 2000, but in but in 2015, my lord, the new learned advocate was engaged to take symbolic possession of the Schedule A property. Now, my lord,
Yes.
now if your lordship kindly come straightway to the execution petition, the Xerox copy I have handed over at page number 23.
Let us first understand this the scope of law in this regard. I do not know that what you are saying is within the purview of that particular execution proceedings. Once the decree has been passed and put into execution, then there are three aspects the executing court will look into. To my very little understanding on this subject to if you enlighten me more if I am wrong.
My lord,
What is required is whether the decree is capable of being executed.
my lord, we as yet not reached, the parties as yet not reached, the court did not decide
No,
whether there is at all a decree has been drawn up.
I am
There is no decree in
I
my
am-
respective submission.
I am correct. So first thing is that's why I was coming. First thing is executability, whether the decree is capable of execution or not. That's the first point I raise. For the reason being, you said that there was no decree at all.
Drawn up.
I'm
Decree was
I'm-
directed to be drawn up, but not drawn up, according to me.
whatever. Suppose if the decree there is no decree drawn up or a decree drawn up. These are all the questions. Only thing is it relates to an executability and the execution case, whether execution case can be maintained. That's the first point. What has happened? What has not happened? Preliminary decree, rightly passed, wrongly passed, is not a subject matter here, to my little understanding. Final decree suffers from vices, suffers from irregularities, illegalities, infirmities. Not a question to be decided. The question is only whether this decree is executable in nature or not, or there has been a discharge, there has been a satisfaction of a decree. Now, I do not know. You'll have to enlighten me on this, whether executing court can go beyond the decree, provided there is a decree.
Here I join. Here, this is my
Please,
submission, provided
please.
there is decree.
Please
Now your
enlighten me that there is
Lordship.
no decree
Lordship,
which is capable of execution. No difficulty.
Lordship. Now, my lord, if your lordship kindly come straightway, this is admitted position, my lord. If your lordship wants, at page number 23 of the execution petition, para number 17, the plaintiff himself, the then plaintiff himself, has affirmed that yes, there was honorable court's order, mandatory order. Page number 23, para number 17. Lordship, kindly.
Page number 23.
23.
Give me the first
Execution petition Xerox copy I have handed over, my lord.
page number 23.
23, para number 17.
Yes. Yes.
So admittedly, no substitution is made till date. Till date, no substitution.
When he died,
31st May 2008.
after the final decree is passed,
Final decree, whether or not, madam, that is also
was-
my respect
that I find from the judgment,
my lord, at page 43.
2007, I do not know. I find from the judgment impugned that it is 2007.
My lord.
1912,
My lord, may I submit, my lord? Honorable Justice,
December 1912.
my lord, 1912, 2007 order is at page number 43 of the execution petition.
Correct. 47.
Of the 43 of the execution petition.
Forty-three
Lord.
is
This does not speak about
Yes.
final decree.
just. There will be a decree in terms of the terms of settlement.
Terms of settlement. I'm grateful.
So
to
the
you.
legally will be,
Decree,
correct.
not final decree. Not final decree.
I do not know what is the distinction between
Final decree
decree
if,
and a final decree.
my lord, the final decree is a decree. There can be several final decrees in a suit. But in this case, a final decree, if is directed to be drawn up, commissioner has to be discharged under the law. Commissioner has to comply with Order 26, Rule 13 and 14 of the Code of Civil Procedure. Satisfaction has to be recorded by the court. Yes, the commissioner, learned commissioner, has handed over the possession to the parties. The order dated 22nd June 2009.
Is it necessary?
My
Can I
lord.
get the law?
My lord, may I speak? My lord,
again,
my
I am
lord,
saying,
if I am wrong, lordship, of course, will dismiss my
I am also thinking if I am wrong,
but
I
what
must
I
be
am-
corrected.
My lord,
I must
my
be
lord.
corrected.
my lord, may I submit, my lord?
Let me understand. I do not
The
know.
page-
In
the
a
page-
partition suit, a final decree will contain all these things that the commissioner has to hand over the position. Commissioner has to do everything, and then the final decree can be passed. I have not. I'm not aware. To be very frank, ignorance. Please pardon my ignorance on this proposition of law. Let
lord,
me
why-
understand what can be done in a
My lord.
final decree and what is done in the final decree.
My lord, why I am submitting so? That is not my version. There is Honorable Supreme Court judgment, my lord.
What I say, I want to be corrected. Please show us
My lord,
that judgment that the final decree cannot be passed unless the partition commissioners hands over the position, did everything, then and then the final decree can be passed.
my lord, in a petition suit, if there is no declaration by a court about the shares of the parties, if there is no appointment of the learned advocate commissioner, there could have been a final decree. But if there is an order by this court or by the court of law concerned hearing petition suit, wherein shares of the parties are declared and read with the circumstances, advocate commissioner has been appointed to take care of the properties and to file a scheme of partition or etc. as prayed by the parties. Therein, my lord, unless the learned advocate commissioner's report is placed before the court and the court accordingly records, yes, to the satisfaction of the parties, the learned advocate commissioner has filed the report, possession were handed over, so final decree be drawn up. My lord, that is the proposition of law so far I understood. Now, my
I
lord,
understood a bit differently. What I understood is
Well,
that
may I
yes,
read the
after the
definition?
declaration of the shares of the parties, it is a duty of the court under Order 26 to appoint a partition commissioner. The partition commissioners will go and do the exercise as required in keeping in mind the shares of the party declared in terms of the preliminary decree. And in the meantime, if the parties have decided to settle amicably, then in that event and files the terms of settlement before the court, then is there any fetter, which I am asking, I do not know,
Hello.
on the part of the court to pass a final decree respecting the terms of settlements of the parties because they themselves have chosen to divide their shares in a particular fashion. If the court accepted it, then what is more?
This terms of settlement reflects future course of action by the parties. So if the future course of action by the parties is indicated in the terms of settlement, and that to be done within 2 years, So on the date itself, it cannot be final decree. 1912-2007, therefrom 1912-1612-2009 is the period within which the original parties were supposed to make construction and to shift to their respective lots. All other contingencies, contracts has to be taken care of within this 2 years period. Now, my lord, that was
Let us take an example of the other suit. A suit for eviction of a person from the property is passed, and a decree contemplates that you'll have to vacate the premises for a period, say within a period of 1 year from the date of the decree. It's a future course of action. What I perceived from such decree, that the decree cannot be said to be a nullity, or decree cannot be said to be a non-decree, or no decree in eye of law. Because what is intended is the postponement of an execution case to be levied for the purpose of recovery of possession. For a period of 1 year, there cannot be an execution because the parties have been given an opportunity. Many a decree, every decree for recovery of possession, you will find there is a time given in the final decree that within 4 months, 2 months, 1 year, whatever, you should vacate. That means no execution case can be levied within that particular period which has been provided in the decree. Similarly, if the parties have said, if they said that yes, these are all the final separation. These are the parties have agreed to do this, and the time limit is given with for a period of 2 years to complete it. Suppose if somebody does not, then definitely that decree can be executed after the lapse of 2 years, because that is the period which is provided for doing all such exercise. Please correct me. I'm again saying my ignorance or understanding may be wrong. A person should not remain in confusion throughout his life. He should always correct himself. I am ready to correct, because if I understood it wrongly, ready to correct.
My lord, may I respectfully submit, my lord, the tenant who was directed to vacate the premises is in black and white that after expiry of a period, he cannot remain there anymore. Execution case can be filed, and that is the deterrence order upon the tenant. That you are getting 1 year time. Thereafter, you have to vacate or execution case will be filed.
No, you have to vacate within 1 year.
That's correct. Thereafter, execution case, if he does not vacate. Now, that is, there is no contingencies, clauses to be complied with, cooperation is necessary, nothing of this sort. But in a partition suit, when parties are having the equal right of share in the property, and when admittedly, learned advocate commissioner recorded the objection of the defendant number 1, original defendant number 1, and the incomplete report was filed, and that was that.
Can it be gone into an execution case?
My lord, may I submit?
Because that may be a good ground. That may be a good ground to challenge the final decree before the court of law. That it is definitely an incomplete one. There is nothing which comes on the record. You can challenge those grounds.
My lord, this is very hairline submission I am trying to make, my lord. Your lordship is accepting as if there is a decree has been drawn. On that score, your lordship.
Second question,
my lord.
If a decree has already been passed, suppose if a decree is not drawn up, does it efface the decree from the court of record?
My lord, because I am unable to execute it. Defendant number 1 failed to execute it because the records of the court are not complete. Because for the substitution, they being not substituted.
Is it required a substitution?
My lord, if there is
under order 22.
My lord, rule 12, lordship on the last date has
whether it applies to an execution proceeding.
If that execution is filed in accordance with law, otherwise, my lord, order 21, rule 11 will come in the picture. Because that was not complied with in the execution case itself. Because the names of the parties who are not there on record, they have taken steps before the decree was drawn up in 2008 to apportion the property with the all statutory bodies.
Drawn up in 2008.
Lordship?
Now you said before the decree is drawn up in 2008, means it was drawn up in 2008.
No.
You said
no. Sorry, my lord, if I have submitted wrongly. Excuse me, my lord. What I am submitting, in 2014, February, for the first time, the decree has seen the light of the court for the first time. Admittedly, before 24th August 2013, an application has been filed by the plaintiff, by the present plaintiff as a constituted attorney holder, that praying for court instead of approaching the learned register original site under the law, original site rules, that he is not getting the decree. Now he prayed before the court. Why he has prayed before the court? This is why the department, because so far I understood the practice of this court or the any court of law in the trial court, substitution was not there despite the order of the Honorable Court in passed in 16 June 2008. The department is unable to record anything that was admitted by the plaintiff himself. Now the department is not giving the certified copy. Now for that reason, he approached by filing GA number 2889 of 2013 on 24th August without going into the merit of the case. This Honorable Court disposed of that petition, directing the department within a certain period of time, give the certified copy of the decree. So only thereafter decree was drawn up, and thereafter, my lord, this decree was annexed to the execution petition. And that for the first time we came to know there is no substitution petition, there is no compliance, there is no order sheet by the Calcutta Collectorate valuing this schedule property as equal 1/3 share. And that money was taken by the plaintiff at the judicial order of the court on the threat that if I don't pay 1/3 share, I would be arrested, my bank account would be freezed. Knowing full well that under section 54 of the CPC, if I once give this money, I am out of court. And that was practically done. I preferred appeal. In APOT 389 of 2014, on 4th September 2014, the Honorable Division Bench dismissed my petition. Directed go before the executing court, raise all the points, including point of substitution. That was not done till date, excepting on 21st June 2019 in the execution case. At the submission, verbal submission of the defendant number 2's heirs, they were added as part. The plaintiff filed a recalling application, praying before the court that that order may be recalled because final decree has been passed. In the execution case, that is not necessary. Thereafter, the same was dismissed as not pressed. They preferred appeal. Plaintiff preferred appeal. Honorable Appeal Court in APOT 96 of 2019 disposed of the matter without going into the merit of the case, recording that since I have not filed any opposition, but simply that there is a preliminary, there is a decree in final form, not final decree. Final form and final decree are not one and the same word. Final form is there in the terms of settlement, subject to compliance of all contingencies. My lord, I am taking to your lordship all the terms of settlement as a whole. Why this substitution was necessary? This substitution was necessary for the reason because simultaneously both the original party and his heirs cannot be on record. And in fact, they were not on record, but they are acting on behalf of the deceased defendant number 2. They are taking step before the authority. Authority is acting upon the same without finding that whether they are at all on record or not. But I am unable to file any execution case because that is not drawn up in accordance with law. That point was stated before the court. The court stated on 16th November 2015, while dismissing section 47 application of the defendant number 1, holding that since this is a final decree, there is no the exact word, my lord, I am just quoting, referring the order, dismissing my section 47, that yes, it is in form, simpliciter. Nothing has been categorically decided, which was later decided in 4th September 2019, that no, in this suit, in the execution case, all the parties to be added, substituted. So for the first time, which is held by section 21 of the Limitation Act. My lord, the final decree, this word has to be there in my respectful submission as per original side rules that I have annexed in my GA. The department cannot deviate what is there in the order, what is there in the terms of settlement. The suit has come up for final disposal on 19 December 2007 as indicated in page number 61 of the execution case, my lord. That is not there in the either in the order of 19 December 2007 nor in, my lord, the 2008 when the honorable judge signed such decree when the Honorable Judge was not elevated on that date, but later in 2011, when the Honorable Judge was not elevated. Lordship kindly comes to directly execution petition 65. Lordship kindly sees page number 65 of the execution petition. At the bottom.
Yes.
4th February 2008, the Honorable Judge who has signed the decree was not elevated on that date. So the decree
Judge who delivered a judgment was
retired on 16th August 2012.
after that.
After that, and as per the original side rules, well, I have annexed the original side rules. The department, if wants to deviate from the order of the court, passing the
No, where you say? Let us see. Where is the
65 execution petition, page 65. This is part of the decree at the bottom. The Honorable Judge was elevated on 11 June 2011.
Yes. When he signed.
At the bottom, 4th February 2008.
No, that is another person. His name
That is
not there.
master.
That's the master.
That was certified by the Honorable Judge.
Judge, when?
That is 4th February 2008. Because master has placed it before the honorable judge for signing.
No, sir. No, sir. Where is the date of the,
Now, Lordship,
Signing
see
of the
page
judge.
number 65 at the top.
Yes.
Lordship, kindly sees the page number 65 at the top.
yes,
This cause coming on this 19 December 2000 to 2007 for final disposal. On the date itself, when 2 years period is there, that I'm reading my lord the terms of settlement.
yes.
So
When-
this was certified in 2008. So
When-
obviously, my lord, not after 2008, the honorable judge signed it in 2011 or thereafter. And if that be so, Lordship, kindly consider. Who has signed this purported decree at the bottom left?
Who?
3 advocates on record, not the parties. Because decree never been signed by the parties. That is the provision of it. Decree to be signed by the advocate on record. Now, the advocate on record has admittedly deviated what is there in the terms of settlement. That's why, my lord, this is not a decree has been drawn up in accordance with law. Now, Lordship kindly comes to page number 61. That is the certificate copy first page. The cost title starts from the previous page, my lord, that is annexed. That is annexed from the very page number 43 onwards. That is the order. Lordship kindly sees. The collectorate has valued it at page number 61 in adjudication proceedings number 32 of 2007 and 8. Now, this adjudication proceedings under rule 5 of the stamp rule, no notice was served upon the defendant number 1. Only the heirs of the defendant number 2 and the plaintiff participated therein. And this valuation has been made in equal share. All right, if there is final decree, I'm putting this question to myself. The then parties, whether could file equal stamp duty, because that is separated. That is partition, final decree.
I could not get it. Sorry.
If on 19/12/2007, as per the terms of settlement, the final decree is passed on 19/12/2007. So according to final decree, parties are separated. They are possessing independent possession when admittedly in 2024 still we are residing jointly. So this particular stamp duty, which has been valued in equal share, as if the proposed lot A, B, and C of Schedule A property, I'm concerned with Schedule A property, I'm not concerned with, and my lord, the Grested property. Now, my lord, this particular Grested property, there is no issue. But this dwelling house property of the parties for last 150 years, now this particular property has been valued in equal share, stamp duty. But that cannot be done. Because the sued valuation that was made after the final decree, that should be as per the valuation of the each plots, which is having under section 178 independent amenities. And thereafter parties to file. But this adjudication proceedings,
Is
my
it?
lord?
Is it?
But the adjudication proceedings otherwise is not necessary, because this is based on the 19/12/2007. If this is 19/12/2007, so the equal party is given, the money has been taken from me on judicial order. So without any amenities. So how this could be, I'm putting this question to myself, which is the final decree. If final decree, no future course of action is necessary. So these contradictions.
So there is no future course of action in the final decree is contemplated in the act. Because
My
it
lord, may I
is-
read out the Civil Procedure Code section 2?
Please read for my better understanding,
Lordship kindly see.
please.
Decree,
Yes,
section 2.
yes, yes. 212. If I am
This is
22,
2.2.
please read.
Decree means
Means
the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of plaint and the determination of any question within section 144, but shall not include any adjudication from which an appeal lies as an appeal from an order or any order dismissal for default. Explanation. And this is important. A decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of.
Correct.
It is final when such adjudication completely disposes of the suit. It may be partly, may be final, which is there in our case. At the first line of the terms of settlement, well, directly may I refer to the terms of settlement in execution petition, page number 43. Lordship kindly sees. So we fall under partly preliminary, partly final. Page 46.
yes,
Lordship got page 46, my lord, of the
Yes, sir.
execution petition.
yes,
By consent of the parties, the instant petition, that is the exception application filed by the defendant number 1 in GA 3419, is disposed of, not the suit.
yes,
And the suit is decreed in part, partitioning the properties in schedule A, B, C, D to the plaintiff in the manner as follows. There will be,
yes.
not there is, there will be decree in final form partitioning the properties mentioned in schedule A, that is the, my lord, I am raising the issue of dwelling house, B, C, D, Darjeeling, in terms of the following. With regard to premises number 88 by 2A, Rafi Ahmed Kidwai Road, Kolkata, particularly mentioned and more fully described as schedule A of the plaintiff, the parties herein accept the scheme of partition being part of return of the learned advocate commissioner, partitioning subject to following. Here starts, my lord, there cannot be final decree. Subject to following. So conditions are there, contingencies are there. This is the contract between the parties. It's an unregistered terms of settlement, does not include the heirs of the original parties, admittedly. And it is not a registered terms of settlement, family settlement, filed before the court after affirming it before the Register of Assurance. Now, Lordship kindly sees thereafter, there are sale clauses. Now, Lordship, the page 47, para A. The defendant number 1, who is recipient of Lot B as mentioned in the scheme of partition, hereby relinquish in all manner southwest corner of the building, schedule A property, which is tenanted and buttoned and bounded by the north staircase leading to such and such. My lord, skipping this part. At the bottom, my lord, last 6 lines, plaintiff who is recipient of Lot A mentioned in the scheme of partition in relation to premises number 88 by 2A at or for consideration of rupees 10 lakh payable by the plaintiff to the defendant number 1, and the defendant number 1 shall execute a deed of conveyance. This was done, but this was not a registered terms of settlement. A sale clause is there. There are other sale clauses. Sale clause is there. It ought to have been registered, filed thereafter before the learned court, before the honorable court. Now, this is part one. Then your lordship kindly sees question of letters of appointment at page number 48, paragraph number a. Small AAA, page number 48 at the bottom, intended to be purchased.
Yes.
Thereafter, your lordship kindly sees paragraph 40, page 49, paragraph number II, last paragraph of page number 49 of the terms of settlement.
Yes.
The plaintiff and defendant number one shall be reciprocally bound to extend all cooperation to each other during construction and repair of the respective portion of the allotments mentioned above. So, future course of action. So, this reciprocal cooperation admittedly was not done because lordship knows the order dated 20th April 2012 and 30th April 2012, wherein they refused to sign the building plan, filed on 9th July 2011 as per the court's order by the defendant number one, giving the mother SSC number because the separate apportioned SSC number was stated by the honorable court. So that was not done. Thereafter, lordship kindly comes to page number 50. Paragraph number III, small, first paragraph. The plaintiff shall pay to the defendant number one this amount for execution of estimated works to be done in Lot B as OLT money. The figure is 1,86,611 in 2007. We are in 2024. Now, this OLT money was given for estimated work. Now, admittedly, lordship has already perhaps found, my lord, in the hearing of this appeal, which was not also considered by the impugned order, but considered earlier by the executing court itself, that corporation intervention is necessary. Now, that is already stated by defendant number one to the Learned Advocate Commission. Learned Advocate Commissioner has indicated so in her report, which is part of GA number 1493 of 2009, which is left open for consideration in future by the Honorable Court by order dated 7th March 2011. Now, my lord, this particular part, the future course of action and construction, I cannot make at my whims. It has to be supported by the corporation's building sanction plan, which was negated both by Director General of Building, report filed before this court, as well as by the Chief Manager Revenue of the Calcutta Municipal Corporation in 2015. One is 2011, another is 2015. So, this future course of action is there. Now, lordship, para 6 of page number 50. The party shall shift to their respective allotted lots, namely lot A, B, C, by releasing the portion of the other lots that they are occupying within a period of 2 years from date hereof, that is from 19 December 2007. In the meantime, parties herein shall make all payments mentioned above. Within the said 2 years period, the allottees shall occupy their respective portion by releasing other portion in favor of the other allottees, so that the partition can take effect. Partition can take effect by metes and bounds. If there is a final degree, there is metes and bound partition. There is no question of further future course of action in a partition suit, because we have already shifted to each other lots. So, on 2007, 19 December itself, when the terms of settlement was accepted by this court, without entering into the merit and demerit of the terms of settlement, whether it is prepared in accordance with law or not, the parties have decided within themselves that yes, we are filing it wherein construction is necessary, and the valuer surveyor has categorically stated that this is a narrow strip of land, proposed lot B, which has fallen in the defendant number one part, has to be constructed with certain number of bathrooms, kitchen, staircase, etc. But wherein that is not stated. For that reason, GA number 1361 was filed, because as per the building rule, garage has to be shown. Now, thereafter, the Honorable Division Bench on 8 June 2011, read with 26 June to 20 June 2011, directed that you file the plan. So we have filed the plan. So, my lord, if there is final decree, there is no execution case pending in 2011 or in 2010. The execution case was pending since 2nd March 2014 or February last part 2014. So there was no execution case. The question of, because the decree has not been drawn up, and the decree wherein has to be drawn up, that was drawn up in a manner and way, Lordship kindly comes to page number 62 of the execution petition. The cause title of the decree shows the names of the plaintiff who was alive in 2014, the name of the defendant number 1 who was alive in 2014, name of defendant number 2 is shown alive, who was not there, passed away long back in 2008. 6 years back, with the order and rider for filing substitution petition. Now, this suit was drawn up, decree was drawn up. Now, this decree was drawn up in a manner which is not there in the order of the Honorable Justice Moharaj Sinha. Decree to be drawn up in terms of the terms of settlement with the contingencies admittedly. So, if the decree is in accordance with law, then under Order 21, Rule 11, name of the deceased defendant number 2 cannot be there. Lordship kindly says Order 21, Rule 11. Once this Order 21, Rule 11 says how a written execution case is to be filed. Party's name is to be given. Now, from 2008 to 2012, the department cannot draw up a decree showing a defendant is alive, because as it has fallen from my lords, that under Order 22, Rule 12, in the execution case, no substitution is necessary. Party's name can be added. Even that was not done. While in 2014, the execution case was filed, the party's name were not there. The heirs of the defendant number 2. So, Order 22, Rule 12, even the plaintiff didn't avail. All this has happened, has prejudiced the defendant number 1, because he has suffered, because they are not party in the proceeding. We cannot take, because they have already apportioned the property behind our back. We had filed objection, defendant number 1 filed objection before the corporation. Corporation didn't adhere to. Those are part of GA number 1493 of 2009. Those parts were left open for consideration by the Honorable Court. The rider which is made while dismissing Section 47 application, that it is a final decree. So this rider in the order dated 19 December 2007 has not been amended as per the order of the subsequent order of dismissal of Section 47, because naming the final decree in the order dated 19 December, which is a decree as per the order. So subsequent order, which is modifying, stating that that is the final decree, has to be amended. That was not done. So, in one hand, 19 December order remains as decree. On the other hand, on 16 November 2015, the order is named as final decree. Well, that certificate by the subsequent proceedings in an execution case, which was passed in suit, in an execution case, the executing court itself gone behind the decree. It is not the defendant number 1 trying to place something to go behind the decree. The court itself gone behind the decree. The department has gone behind the decree. The department has disposed of the suit. Page number 65. Suit has come up for final disposal. There is no judicial order disposing of CS3 of 2005, the partition suit. To infer that suit has been disposed of by virtue of the terms of settlement, which itself speaks it's a part decree, and a suit cannot be. If the suit is disposed of, then on 21st June 2019, read with 19 July 2019, read with division bench order which was challenged by plaintiff in appeal, 4th September 2019, couldn't have directed the parties to amend the cause title of the suit, which means suit was pending, but abated. Because it's not a final decree. If there is a final decree, application of substitution does not apply. Simplicity addition of the party would suffice. Now, this was that those are part of the record. Now, my lord, these in one side, in one hand, that the terms of settlement read with the department's action, disposing of the suit, signed by the learned three advocate on records at the then point of time, totally prejudiced because the parties or the defendant number one originally didn't know what is signed in the decree. Because terms of settlement was signed by the parties. Lordship kindly come.
What the defendant number one used to do,
Advocate.
and he does not know that what he is signing.
Yes, terms of settlement he has signed. He didn't sign the decree because under the law,
Decree.
yes, what that I am submitting. The decree has not been signed by the parties. The decree was signed by the advocate on record, deviating from the terms of settlement. Suit has come up for final disposal, that is not there in the terms of settlement. So this insertion of the words, that is the violation of the order of the Honorable Justice Moratsina. And that is what the original side rule says. If the department want to deviate, the case has to be listed in the court. The deviation has to be made. The department cannot decide suit has come up for final disposal because that is not there. Neither here nor there. And the word final decree, by the judicial order, that should be there. And for that reason, my lord, the learned executing court in 2022 observed about maintainability of both the execution cases. The court asked why the defendant number one at the point of time failed to file the execution case. And these are the reasons he couldn't file. Because on oath, we cannot, the parties cannot, the advocate cannot write a petition, affirm a petition quoting that one party is alive. Otherwise, substitution is not necessary. The provision does not apply in, if this has become the precedent, then the substitution petition is not necessary. Section 21 is not necessary of Delimitation Act. Now, if your lordship kindly sees, the rider that is made by the department read with the order and the conduct of the collectorate in issuing the certified copy in the year 2014. That page number 61. When it was signed, 21st February 2014. So decree first time seen the light in 2014 February. Thereafter. So my lord, this decree I came to know in 2014 after the execution petition was served upon the original defendant number one. Immediately he prayed so. The Honorable Division Bench in 4/9/2014 directed for deciding the substitution issue. That was not done by the executing court. However, the executing court, while dismissed the section 47 application, res part favored the defendant number one about the construction part. This honorable court, when the decree was not drawn up, on 11th January 2010, appointed corporation to see whether the proposed lot B can be made self-sufficient. But the corporation, on the other hand, just acted contrary in apportioning the property ex parte. So, my lord, the decree whether has been drawn up in accordance with law or not, and why all these fishy issues done by the department, because Lot A and Lot C proposed are having most of the amenities. Admittedly, proposed Lot B having no amenities. In fact, in one hearing, Honorable Division Bench in 2012, before dismissal of APO 423 of 2010, although stayed the apportionment, extended the period after dismissal, which was never prayed for stay, observed, why don't you sell out your share?
Why don't you?
Sell out your proposed Lot B share to the other parties. Then we prayed, My lord, let them sell to us. We shall buy it. My lord, this is the observation of the court when the defendant number 1 tried his level best to make the construction after the court's order. Now, Lordship knows, my lord, the Honorable Division Bench, we have challenged that under Section 178, the Corporation Act, the building falling under Chapter 72 of the KMC Act. Therein, no construction can be made for two reasons. One, the building height is exceeding 54.5 meters. Other, this building is covered area is beyond 50%. That is, it is about 15 cutters of land or 14 cutters of land covered with 10 cutters of constructed area. So no construction can be made even under Section 410 of the KMC Act. Far less to make staircase, bathroom in each floor, and everything. Then, at the point of time, the defendant number 1 prayed before the division bench that unless the property is separated and mutated, equally about the issue of substitution, the defendant number 1 is unable to file a plan. Thereafter, apportionment was stayed, ex parte apportionment, which was done after the Honorable Court's order dated 2nd February and 2nd May 2011, wherein the plaintiff filed an application in the appeal of defendant number 1, praying for mutation. There are 9 kinds of mutation. The Honorable Division Bench directed the corporation take step for mutation. But the department ex parte held as if on record, as if the Honorable Division Bench directed them to apportion the property. It is totally contumacious conduct on the part of the corporation. The Division Bench never stated so. The total construction work was stalled, absolutely violating the terms of settlement, the future course of action. So there cannot be final. This future course of action, the decree, even if assuming is maintainable, then the Honorable Executing Court need not to proceed further. On the date itself could have shifted me to Lord B and the directed the parties to take the possession of each other. Why the Honorable Executing Court has gone behind the decree itself for the reason to give and honor the order of the Honorable Justice Maharaj Sinha. For that reason, directed and passed several orders. Exceptions were filed. Even both the plaintiff and defendant number 2's heirs, who were not on record, that is the heirs of the defendant number 2, has objected and did not sign the plan. If they would have signed the plan in 2012, we by this time, last 12 years, would have shifted in our position. The heirs of the defendant number 1. Now, my lord, what has happened by the Honorable Division Bench? When directed to file the plan, which is still pending, but in 2012, the Honorable Division Bench held as if the corporation dismissed the plan, which was later found by the order dated 8 November 2019 and 13 December 2019. By the report of the corporation, plan is still alive. Now, on the other day, my lord was kind enough to direct whether I myself can construct the plan from G+4 in the proposed Lot B. My lord, I am unable to construct that. I have submitted to your lordship, and already I prayed in my GA number 3 that
I never said that.
No. Whether I can construct.
No, that's construct means in terms of that particular terms and settlement where it says that you are in a, you are permitted to make a staircase, you are permitted to make a, it's not a
plan,
forest story.
the plan
Only thing is
was pending on.
The plan in tune with that particular terms of settlement.
Yes, that is in terms of settlement. Because in the scheme of partition, the valuer surveyor did not indicate where to construct. The open, because the proposed Lot B is having less than 50% constructed area. That is about 60 to 65%. So the rest part we can construct, and that's why the plan was given by the registered empanel land building surveyor, Kamulesh Shil, with the court, and the court directed the corporation to consider the plan, which has been left out by the corporation in last 12 years. So that was not, it is not the fault of the defendant number 1 or myself. They have not done it. Even the division bench order also was not honored by the other parties to sign the plan. Now, lordship, I have whether there can be any rider to the order of the Honorable Justice Moharaj Sinha, my lord.
That you have argued extensively. You need
Do
not
I
have
refer
to.
the provisions, my lord?
Yes, you can just refer those provisions which you want to really rely upon.
Yes, lordship kindly comes to.
Yes.
May I read out, my lord, the section 47 dismissal order passed earlier?
It has already dismissed section 47.
But the latter part, what the honorable courts observed, that part, my lord, I beg to
Please
differ.
show us that portion only.
My lord, GA number 2, if your lordship kindly takes up, GA number 2,
Yes,
page number 40.
yes. Yes,
Lordship kindly comes to page number 40.
that is a single bench decision.
Yes, in the dismissing my section, dismissing defendant number 1, section 47 application.
Then against that, the appeal.
Yes?
Against that, the appeal was preferred or
No,
not? No appeal.
No. Because the honorable division bench found that the defendant number 1 is in difficulty, was in difficulty. Now, my lord, before that, lordship kindly sees the order dated 4/9/2014, which is my lord, may I beg your lordship to take up GA number 1 first? My lord, may I take your lordship to the GA number 1, page number 70/71?
No, you have
Yes,
taken us to that
we
order.
did. Before that, my lord, the order dated 4th September 2014.
No, this is a 16 November 2015.
That is latter. Before that, the learned executing court, honorable executing court was supposed to consider the order dated 4th September 2014.
What is that order?
That is order preferred against the order directing the defendant number 1 by order dated 10th June 2014 and 12th June 2014 to pay the equal 1/3 share of stamp duty of the collectorate. Otherwise, my account would be freezed. I would be arrested. Against that, appeal was preferred. Therein, several points were taken. The honorable court dismissed the appeal and directed to consider the issue of substitution and abatement. That order I beg to defer at page number 70 and 71 in GA number 1 of 2023. My responsible submission, the honorable executing court did not consider, which is apparent after the latter order was passed by the honorable executing court and the
First volume টা কোথায়?
GA number 1.
এটা তো ও দিয়েছে।
My lord, kindly takes, if your lordship kindly takes my list of dates, my lord, all orders are annexed, my lord. The order which my learned friend,
এটা memorandum. Page
70 and 71. Heard the learned counsel for the parties. This is an application for stay of the operation of the orders dated 10 June 2014 and 10th July 2014 and also stay of execution of 171 to the till the disposal of the appeal. We are not inclined to interfere in this matter because two reasons. Firstly, the execution proceedings are pending and all points which are being sought to be raised here can also be raised there. Secondly, the points that are being sought to be raised here were already considered in GA number 3344 of 2010. That is about building construction. Corresponding to APO 423 of 2010 in CS number 3 of 2005. So far as the point relating to substitution is concerned, leave is given to take the point before the executing court. Thus, application and appeal stand dismissed. So, this substitution issues were dealt with by the Honorable Executing Court on 16th November 2015. That is at page number 40. Now, may I read out that part? GA number 2. A decree was passed on 19 December 2007.
Where?
Page 40, GA 2, GA number 2.
Yes.
A decree was passed on 19 December 2007. It was a compromise decree. It was for partition of premises number such and such, along with other properties. An application for execution EC 171 was taken out by the plaintiff for execution of the decree. Another application GA number such and such under section 47 of the code was filed by defendant number 1, namely such and such. In this execution application, various points have been taken on behalf of the said defendant to challenge the decree. First, it was stated it was not a final decree, but a preliminary decree or a part decree. Secondly, it was stated that the decree was inexecutable. It was submitted that the decree provided for division of the premises into lot A, B, C. Lot B had fallen into share of defendant number 1. Lot B was not habitable. The decree provided for some construction to be made. Therefore, unless those constructions were made according to the choice of defendant number 1, the decree could not be executed. Mr. Bhattacharya, learned counsel, submitted that the portion which fell in the share of the defendant number 1 did not provide bathroom, kitchen, staircase, etc. Other ancillary points were taken. Namely, that the decree was not drawn up in accordance with the terms of settlement. The heirs of the defendant number 2 had not been substituted in the execution application, and the execution application was not in proper form. This was the submission that also substitution was not made.
Proceed. All these
Yes,
things
in
were
this
there.
in the suit. As far as substitution of the heirs of the defendant number 2 is concerned, this court noted an earlier order that no substitution was required if a party died after the decree. It was carried in appeal. The appeal, I am told, was dismissed. As far as the first ancillary point is concerned, I think it is of no substance. A certified copy of the decree is annexed to the execution application. Furthermore, a party to compromise decree cannot, in my opinion, turn around and resist execution thereof on the above technical point that a certified copy of the decree has not been annexed. If there was no certified copy of the decree annexed to the execution application, it was the obligation of the defendant number 1 to supply a certified copy of thereof to facilitate the execution. So this certified copy I couldn't get because of the cost title. I have scrutinized the execution application and hold that it is in proper form. In my opinion, this matter has been unnecessarily prolonged for a considerable length of time before this court because of the resistance of defendant number 1. It has also spent similar time before the Court of Appeal at the instance of the same party. The decree is compromise decree for partition. The reference to construction in the said decree only refers to those construction which would be make each of the partition parts of the premises independent and capable of separate enjoyment. In my opinion, the decree does not provide for making substantial construction as the defendant number 1 has indicated in his proposed plan. Substantial construction may be carried out by any of the parties after partition in terms of the decree, in my opinion. Furthermore, the importance of the expression construction to be made in premises was considered by division bench of this court in its judgment and order dated 10 December 2012, where the division bench explained the following. We have noticed that time and again the division bench of this court had passed orders to ensure the parties to compromise decree implement the terms of the settlement without prejudice being caused to any one of them, which has been done in our case. The division bench had directed the defendant number 1 to submit a plan so as to make lot B habitable. It appears, however, that the defendant number 1 submitted a plan which were for construction of a new building on lot B, and it is in these circumstances the competent authority refused to sanction the same. It is not correct observation by the Honorable Court because that was clarified by the corporation. The import of the order dated 24th February 2011 passed by the division bench of this court is ambiguous, unambiguous, inasmuch as the plan which the defendant number 1 was to submit was for construction of staircase, kitchen, a water reservoir, a toilet in Lot B, which fell into the share of defendant number 1 under the consent terms. Instead of submitting such a plan, defendant number 1 submitted a plan depicting the construction of a building at the rear end of Lot B and for connecting the same to the existing structure. It is in this circumstances the sanction of such construction was denied. But if it would have been denied, the date is not given. Not only that, this honorable division bench, wherein the case was assigned, on 20th April directed the other parties to sign the said plan. So if it would have been dismissed, the honorable division bench wouldn't have directed it, and
This
that
is
order is annexed.
Read further.
Most importantly, the defendant number 1 has received rupees 10 lakhs from the plaintiff for agreeing to take Lot B under the decree. Furthermore, he is entitled to further amounts as OLT. Having so agreed by signing the compromise and having acted upon it, the defendant one is stopped from challenging the decree itself is inexecutable. Now, this part, my lord, we have already stated that we are ready to refund even during the lifetime of the defendant number 1. Now it has discovered this particular part is so far concerning southwest portion of the Schedule A property, which has been found discovered in 2023 that is a trust property. Now we are the trustees of the property as per the probated will of our grandfather, which was never fallen as a owner of the original 3 parties. They are not the owners, nor we are the owners. We are the trustees as per the will. So this part, my lord, we have to refund it. And also the plaintiff supposed to give the accounts for the rent he has received till date from 2007. I come to a conclusion that there is no defect in the decree whatsoever which makes inexecutable. Now, these defects which I have pointed out today, my lord, at the first hearing, those were not considered. Those are not there. Because of the reason, my lord, this execution case wherein I was asked.
Why you did not challenge this order before the
Because of the next part, because I wanted to get this decree to be executed.
So now you are raising that all these
Not-
findings are all bad, wrong.
Not me. Now the defendant number 1, plaintiff, original defendant, nobody is there. Now we are not bound by these terms of settlement because the terms of settlement
So
includes
your
confined to
your predecessor, if entered into a terms of settlement,
yes.
then after their death, terms of settlement perishes. And the successors of those party, they are not bound by that terms of settlement.
Because of the reason that is not, first of all, the terms of settlement does not include us. Secondly, it is not registered.
Because you are not, you were not there.
No. My lord,
Or you were there, but your
family settlement arrangement under the law, my lord knows better than me. It has to be registered and then filed because it is out of court. It has to be registered. So the inclusion of the heirs has to be there in the terms of settlement in my respectful submission, which too contains the several sale clauses of several properties. That is not there. I am covered by Supreme Court judgment also, and notwithstanding Supreme Court judgment, my lord knows it because the family arrangement has to be registered. That was not done by the original party. For that reason, my lord, I am submitting section 50 subclause 2 of CPC. My lord, I am submitting section 50 subclause 2 of CPC as has fallen from my lord earlier hearing is not applicable to us. Even section 54 is not applicable to us because those decree, purported decree or the order only confines the original parties. It loses its scopes, soon they are demised. Immediate after demise of original defendant number 2 in 2008. Because to enforce the same, we ought to have been brought on record. At least.
according to you, suppose a decree is passed, say around 1st January 2009, but the decree could not be executed, or say, because the law says a certain time limits within which the decree has to be prepared. Say on 1st of January 2009, the decree is passed. And it appears on 3rd of January 2009, one of the party died. So according to you, when a decree is drawn up on, say, around 13th of January 2009, then it must contain the name of the heir,
Yes,
because the deceased cannot be there in the decree. So in a matter which is finally disposed of on the basis of a decree, a further application for substitution can be taken out to bring the heirs of a deceased party on record. Has to be, because that is what you say.
my lord, that is also order of the Honorable Division Bench. 4th September 2019, in the plaintiff's appeal, plaintiff filed GA 1619 of 2019, praying for of 2019, praying for recalling of the order of the 21st June 2019, wherein the defendant number 1 years were added as party on verbal prayer. That
No,
too.
I am not on that. You were saying that the decree was passed or drawn up without implementing the heirs
Yes.
of a deceased defendant number 2. To that I reacted. It may be a case where 5 years or a 6 years period have been taken. I am giving you a very simple example. Every decree is required to be drawn up. Has
Required to be drawn up in
drawn up
terms of the order.
irrespective, whatever. In terms of the judgment,
Order. Yes.
whatever order, judgment is to be there.
Lordship.
Forget. You are also a practicing advocate.
Lordship.
Forget about your case. Let us see a common thing. Judgment is passed, as I gave you an example, on 1st January. On 3rd January, one of the defendant or a plaintiff, whoever be, died. 3rd, after the judgment is delivered. The decree is sought to be drawn up on 13th of January. So naturally, on 3rd, one of the party has died. So according to you, what should be the course of action for drawing up the decree? Can it be drawn up keeping the name of a deceased?
No.
Or then how the heirs are to be brought on record?
Filing substitution.
Where?
In the suit itself.
In the suit, which has already been disposed of by virtue of a
It is
judgment.
not there in our case.
I'm asking you
Yes, my lord.
in a general. That's why I say you are a lawyer.
Yes.
Forget this case.
Yes.
Common. Can a substitution be filed in a disposed of suit because the judgment is a final?
If the judgment is final, if the suit is disposed of, no substitution can be filed in the suit.
Then how the decree is to be drawn up in the name of a dead person?
Decree is to be drawn up in the name of the dead person. Now, my lord, if now it is not me to settle the law. What is there in the substitution petition? What is there in the my lord section 2.2 of the definition of decree? My lord, what is there in our case record? There is no disposal order of suit. There is no disposal order of rather recording of final decree. These two parts are not there.
Correct. So we'll decide that. Yes. Any law, anything
My
you
lord,
want to?
more submission
Because you have said that you have already filed a written argument. I think.
Yes, that I filed on
Yes.
150
So
pages.
concentrate on that, and whatever you want,
My lord,
you cannot.
my lord, what, my lord, because of the reason, few judgments I beg to submit, and the
cite those
other
judgments.
points, may I take few?
You have taken it in your written arguments. There is no difficulty. Each and every point would be dealt with.
Only one part, my lord, what I found, discovered
take-
yesterday night.
Yes.
This particular, I am, for this, just may I read out, because the copies I have not made. This is the report of the corporation filed before the executing court after this, before this order dismissal of section 47, wherein the Honorable Executing Court, by passing several orders, directed corporation to file a report. This Chief Manager Revenue, what says, my lord, may I just read out? It's a very small 2 pages. It was addressed to the
Court.
by the Chief Manager Revenue of Corporation concerning this issue of building, construction, etc. What we have stated since 2008 by filing GA 1361. And
But in a appeal, can we take note of any document which do not form part
Then-
of the record.
My lord, this is with them also because this is part of the record.
It is a-
I couldn't annex it because I discovered it while I
No
was
difficulty, no
arranging
difficulty.
because
You
there are
just
voluminous documents.
give a photocopy of it.
My lord, I
consider.
shall.
Don't
Should
worry.
I continue next half?
Yes, no, you have to continue.
Lordship.
Continue. You will not keep the matter alive.
Lordship kindly comes to GA number 1, page 159 to 172 original side rules I have annexed. Page number 159. And before that, my lord, that I was not heard is at page 148 by the learned executing court, honorable executing court. Page 159, letters patent clause 2. High Court is the court of record. My lord, may I read out the clause 2? And we do by this present grant, direct and ordain that notwithstanding the revocation of page 159 of GA number 1. It may be in the second part, my lord. Letters patent clause 2, 1865. And we do by this present grant, direct and ordain that notwithstanding the revocation of the said letters patent of the 14th of May 1862, the High Court of Judicature, called the High Court of Judicature at Fort William in Bengal, shall be and continue as from time to time of the original erection and establishment thereof, the High Court of Judicature at Fort William in Bengal or Bengal Division of the Presidency of Fort William, aforesaid, and that the said court shall be and continue a court of record, and that all proceedings commenced in the said High Court prior to date of publication of this letters patent shall be continued and dependent in the High Court, as if they had commenced in the said High Court after the date of such publication. And this part I am relying upon on this issue. The Honorable Justice Maharaj Sinha passed an order. So that is the order of the court of record of this Honorable Court. Read with my lord, 1865. Yes, before publication of this letters patent, 1865, before 1865. This is after 1865. But the court of record continue to be court of record. I am on this. This is read.
That is also a constitutional provision.
Yes, Article 215.
205.
Yes, I'm grateful to your lordship. So the order passed by Honorable Justice Maharaj Sinha is the court of record. So that cannot be touched unless there is a recalling or review application filed, unless a substantive application is filed. So if that order does not contain disposal of suit, if it does contain instead a decree to be drawn up, not final decree, in terms of the terms of settlement. So, my lord, this thing is.
So we got your point.
Yes,
You need
yes.
not have to elaborate
Not-
that. You said that it is not a final decree.
Not-
The final decree and a decree in final form are two distinct factors.
Yes, my lord, grateful to you.
We got you.
Good.
Yes, that's then.
Then, my lord, next page. Page 160, clause 11, chapter 6, clause 11. At the bottom. Business to be disposed of in chambers by a judge. Which has to be disposed of in chamber. Now, clause 1, application for payment of transfer to any person or any cash security.
Not necessary here.
Now, death, next part. 161, marriage or death of any person. This death of any person, it has to be notified to the court by filing a chamber application. That was not done, admittedly, till date. Now, your lordship kindly comes to page 163, chapter 16, clause 1. Judgment, decree and orders. This is the chapter is dealing with. The first clause. The judgment shall be pronounced in open court and minute thereof made by the principal officer in attendance in court, and the decree or order shall be drawn up in accordance therewith, which is not done in our case. Where the judgment pronounced has been reduced into writing, the decree or order shall not be filed before such judgment is filed. Next, your lordship kindly comes to page 165. I am skipping clause 6 because while the application was before the court, GA number 3419 of 2006, on that day, terms of settlement was filed and the decree was passed in terms of the terms of settlement. So, my lord, I am not going to rule 6. Now, your lordship kindly sees unless clause 8, unless the court or a judge shall otherwise direct, a party consenting to a decree or order shall appear before the court or a judge and signify such consent by an advocate acting in the original side, or where he has no advocate acting in original side in person or by recognized agent. Well, that was done through our advocate. The terms of settlement was filed, duly signed by 3 parties and 3 advocates on records of the terms of settlement, but not the decree. Next, my lord, clause 8, how the consent is signified, that is there. Page 165. Before a decree or order is passed in any suit or matter on compromise, which provides for discharge of a receiver. This I was submitting, my lord, by order dated 8th March 2005. Receiver was appointed, that is the advocate commissioner was appointed, not receiver, not receiver, advocate commissioner was appointed.
So it has.
No, order 40 does not apply. Order 40 does not apply.
Yes.
Order
Between
26
a
does
receiver
apply.
and a partition
Exactly.
commissioner.
My lord, I am sorry, my lord. Order 26 does apply. So, my lord, so I am skipping this part, my lord. 10, page 166, clause 10. Decrees to be drawn up, signed and sealed and dated. Every decree shall, upon application under Rule 27, be drawn up in the office of the registrar and be signed by the registrar or master and by the judge. That was done in our case. And sealed with seal of the court and shall bear the same date as I was submitting on 4th February 2008. Although the decree was passed on 19 December 2007. As the judgment in the suit, provided that if by reason of the absence of the judge who passed the decree or from any other cause, it cannot be signed by him, such decree may be signed by the judge taking the list of the judge who passed the decree, or if there is no such judge at that time by any other judge. This was not there in our case. Honorable Justice Sinha was available on particular date.
On the date when the decree was drawn up.
That was in 2014. Maybe. I do not know.
Was Justice Sinha there?
No. Whether in 2000, because when the decree was drawn up, it to be treated as 19 December 2007 because that is the decree enclosed.
That will bear the date of the judgment.
Yes. My lord, the order.
There is a distinction between a date of the judgment to be incorporated
and the date of the decree.
And no, sir.
Date of the
and the signing of a decree.
Yes. Signing of this decree was done
in 2014.
No, that is not there. That is my submission.
Sir,
that is my submission.
That is what is there. You said that the decree was not there. Application was made. Application was allowed. Thereafter, the decree was drawn up. All these things came in 2014, according to you, by an order of the,
My lord,
the court.
Perhaps I couldn't express myself. as I could express myself. Three parts. One is the order date, 19 December 2007, on which date the terms of settlement was filed. Other is the decree to be drawn up in terms of the terms of settlement. Only one date we are getting available, that is 4th February 2008. And another date is available, that is 19 December 2007, wherein in the body of the purported decree, suit has
Sir,
come up
it
for
does
final.
not, it does not say so, sir. What it says is the decree may have been drawn up in 2008, but maybe a lapses of the department that this decree, which was drawn up by the department, was not placed before the judge who delivered a judgment. Ultimately, what happens is it was lying in the court's record or lying in the department. No steps were taken by the department to get it signed by a judge who passed the judgment. Later on, when there is an order of this court that you can't keep the decree in such fashion, you'll have to get it duly drawn up and signed by the judge. The learned judge who passed the judgment was not available.
He was available till 2012.
Great. So it was after that, because you said that there was a direction passed by a court to draw up a decree,
Yes,
to sign a decree. You
Yes.
said that there was order.
yes.
When that order was passed,
19 December.
19.
Because there is no other order concerning terms of settlement.
Sir, probably you are not. You are either. May I?
And I'm
use
sorry, my lord.
may I
I
use
couldn't
the
follow,
word
my lord.
beleaguered with
My lord.
all the facts, or consciously avoiding?
My lord, I am a
Say,
last person to
sir,
consciously avoid anything.
Sir,
I'm the
let
last
us
person.
understand, sir. There are several issues you are flagging up. You are really jumbling up, or rather beleaguered with those facts. When a so-called, I am using, because you are very skeptical about using the words. Let us see so-called the decree in final form. I'm not using the final decree consciously because you are taking plea. On 19 December 2007 is concerned. According to you, two aspects. One is it is not a final decree. And if it is not a final decree, then in that event, there is no question of decree to be drawn up. Obviously, when there is no final decree passed, then the question of drawing up of the final decree does not arise at all. Suppose if it is a decree in final form, then a decree is required to be drawn up. If the decree is required to be drawn up, then this says that it must conform to a judgment. What is the judgment? Judgment says that terms of settlement which was filed before the court is accepted, and decree in terms of prayer A. That is what is only say a decree. Not in terms of prayer A decree is to be drawn up on the basis of terms of settlement. Now it appears that the decree, though it was drawn up by the department on 2008, February or August,
4th
whatever.
February 2008. 4th February
4th
2008.
February, but was not signed by the judge. Then the two things arises. One is the judge who has signed the decree, as it appears his name therefrom, was never elevated on the day of when the decree was formally prepared. Now question is not drawn up, it's prepared by a department. He was not there. The learned judge who passed the decree was available. But it appears that he did not sign or could not sign. For whatever reasons, we are not entering into this. The decree appears to have been signed by a judge at a relevant point of time, though there is no date he put before he signed the decree. Ought to happen.
As per
Ought to
what's
have been.
been.
Ought
Yes.
to have been. He has not.
It
put.
would be presumed that on that day.
It would be not presumed, sir. It would be presumed that he signed the decree after the judge who delivered the judgment demitted an office. Obviously after that. Otherwise, he could not have signed the decree. Could not have. There's no question. A person who is a member of the bar will sign a decree as a judge. What are you talking about in
I'm
2008?
not talking. That is why I say submitted department is involved in this issue.
Something which must be,
Department is involved.
sir,
They are
something
they are
which
enough
must be,
to
sir,
take a name of the honorable
sir,
judge.
this point would not have been taken if the learned judge who delivered a judgment signed the decree.
Yes,
No difficult.
yes.
No. That means the logical inference one can draw in the course of the proceeding is that the learned judge who signed the decree after the learned judge who delivered a judgment demits an office. That's a logical inference one would draw. Nobody, something which is absurd, something which is improbable, cannot be conceived of in a legal parlance. You can't take advantage of that. Now, first question has to be decided whether that judgment saying that a decree in terms of a compromise or a terms of settlement is a final decree or a decree in final form. If the court holds it is a final decree or a decree in final form, whether the second question is that the decree is required to be drawn up. If the decree is required to be drawn up, these are all ministerial part. And the presumption, which is more legal, there are distinction between may presume and should presume under the Evidence Act. May presume is something different, which requires a further, and should presume means that there is no other option but to presume this. So you cannot say in that sense that this decree is otherwise faulty, because we have to decide the first question. Whether it is a final decree or a decree in final form. What is the distinction in between that?
Because
Or it is a taller decree.
now this has been answered by the honorable division bench.
That's already, if it is already answered,
2019.
if it is already answered,
Matlab,
can
that's
it
the-
be re-answered by the
No.
court, coordinate bench?
So the court said what is there in the terms of settlement, that subject to compliance of all contingencies, there will be decree in final form. So decree will be in final form and final decree, both are not one and the same.
That is what I say, that
Yes,
we have
and
to
that is
decide
confirmed.
that.
Yes,
We have to decide that.
Yes,
You
that
have
is-
coined two words, two words.
yes.
One is a final decree and a decree in final form. According to you, both are not synonymous.
Yes.
They are not one and identical. Let us decide whether those are one and identical, synonymous or not synonymous.
My lord, may I read out this order dated 4th?
Not necessary. We'll decide it.
Yes, my lord, that is already decided by the honorable division bench.
Correct. So
4th
can we,
September.
then what it says is in final form.
No, preliminary decree in final form so far concerning 4 properties. What is there in the terms of settlement? Not said that this is the final decree.
Oh, that is what I'm saying.
Yes, yes.
So we have to say that if it is treated as a decree in final form,
Decree in final.
then it is not a declaratory decree. We will decide it. What
My
does it mean? If there are two courses for us. One is if we say that the final decree and a decree in final form are two distinct facets. It is not synonymous or identical or similar. Then the earlier division bench has already held the decree in final form. We cannot take a divergent view to that effect. Cannot, because it's binding on us, being a coordinate bench. If we hold, then the second option is that the final decree and the decree in final form are the one and the same. So if the expression has already been used, that would tantamount to a final decree, and the drawing up of the decree is not a issue. Then also we have to say that both are similar. This is the only scope, very limited. That's the only thing. Let us decide that. Let us decide that. I do not know. If you tell me, then That is pointing out that the 4th December order does not talk about it.
September order, what does it decide?
4 September 2019 was preferred against the order dated 21st June 2019 by the plaintiff.
19.
Yes. There are common this 4th September. One is of 2014.
14. That is what my brother
Yes.
was looking at.
That is because for that reason I'm repeating this year.
No,
Yes.
don't worry. So that is the only thing. We'll decide that.
Read
problem.
with my lord the circumstances, whether a cause title can bear a person is alive, a litigant is alive in a decree when he has died, followed by the order of this court. My lord, let them answer, then thereafter I shall take the other points.
No.
I shall complete.
No, complete.
Lordship.
Complete.
Now, my lord.
Not
Lordship.
in isolation, sir.
Not lordship.
Or in a
lordship.
piecemeal.
No,
sir.
I thought that.
So I just wanted that what you wanted to do is just reproduction so that you may not elaborate much.
No, I'm not elaborating.
Yes, then.
My lord, I was referring to, my lord, this original side rules.
Yes, no difficulty. You have said that what is required under the
Rule
rules.
10.
Yes, everything you have said. We'll
Rule-
take note of those rules
Yes.
and then its applicability
Yes.
in the perspective of the present fact.
Lordship.
No
Now,
difficulty.
rule 10 I have submitted.
Yes, no difficulty. Sir.
Every decree shall.
Yes, it should be signed either by the registrar or a master registrar and by judge.
And by the judge. And by the judge.
Right. So either
by the
registrar
judge-
or master, but the judge
Supported by
also.
the judge.
Or
Signature.
yeah,
Now, my lord, herein this signature of the honorable judge, obviously,
which does not bear any date, and if the master or the registrar has signed with the date, it will be presumed.
my lord, perhaps I'm
Perhaps.
joining back to join issue herein.
Yes.
This rule 10 says categorically, register and be signed by the registrar or master and by the judge,
Correct. Correct.
sealed with the court, and shall bear the same date.
Correct.
So it is obviously on that particular 4th February 2008, the honorable judge has signed it. It cannot be a different date.
Then why proviso was inserted?
My lord, provided that if by the reason of absence of the judge, that is, if Honorable Justice Mohammad Sinha was not available on that date, then it could have been taken a next date by the department to bring it notice to the honorable judge and to get it signed. What necessitated the department to get
To sit over the
Yes.
decree for such a long time.
not
at
not
the moment-
such a not long time. The issue is coming for final disposal in page number
So
65.
that is again you are going back, sir.
Lordship, kindly excuse me.
Yeah.
My lord, what is problem? What has rather the issue created a problem? The department has sought to exercise a judicial dictum or judicial function without the leave of the
No difficulty.
whether we, notwithstanding a litigant, an advocate, can act
Yes.
upon that.
Correct. We'll take
Because
care
we
of that.
cannot file an execution case on this illegal terms what the department has done.
Done.
We cannot do this.
Yes.
And that has created our problem. Despite such fact,
Correct.
we
Sir.
tried to get the plan sanctioned.
Yes.
They refused to sign. So we are suffering
Yes.
since 2011 after filing
Yes.
at the order of the court.
Correct.
Whether
Sir.
we can be punished today in 2024
Or-
for their action.
Correct.
Now, my lord, this rule 11, contents of the decree.
Yes, sir.
A decree shall contain the number of the suit, the names and description of the parties, which is absent in the decree itself, and particulars of the claim as stated in concise statement, and shall state what parties appeared and how and whether any evidence was taken, and shall specify clearly the relief granted or other determination of the suit. But no issues or findings thereon shall be inserted unless by special direction of the judge, nor shall there be any recitals other than such short ones as the registrar or master thinks necessary. Money and security, last sentence, we are not concerned. So this part of Rule 11 is absolutely in contrary the department has done.
Yes. Then
Stating suit has disposed of,
Correct.
stating it's a finality.
correct, sir.
Thereafter, Lordship, kindly come. Rule 18, page 168.
Yes, sir.
Provisions in partition decree.
Correct.
Unless the court or a judge shall otherwise direct, every decree for partition shall provide OLT mutual transfer. So this mutual transfer has yet not taken place during the lifetime or today with us. Cost of the decree, subsequent cost for payment by the parties respectively of the cost of issuing and executing the commission of the partition and confirming the commissioner's return in proportion to the value of their respective share. This on 10th June and 10th July, the Honorable Executing Court passed order against the defendant number 1, for which we preferred appeal. So all these costs were not decided, even Rule 18 has not been taken into consideration. So equal valuation of my lot B with that of lot A and lot C cannot be the same under the law. So this Rule 18 subclause 4 applies in the decree, which is not there in the decree itself.
Yes.
So the decree has not been drawn up in accordance with law.
Yes.
Now, Lordship kindly comes to Rule 90. Page 169. In every decree or order that it is not final,
No.
liberty to apply.
Don't impute the word it.
My lord,
Don't impute the word it.
in every decree.
It's you have used after that it. It is not there.
Sorry, my
It
lord, if I have
simply
to-
says that in
Sir, if I
every
say so, my
decree
lord,
or order
my lord, I'm sorry.
that is not final.
That is not final.
That you say that it is not final. There is a clear
lord,
distinction.
My lord, I'm sorry, my lord.
Don't use the word it.
My lord,
It's not there.
If I have used, I am withdrawing it, my
Yes.
lord, because
That is not
mistakenly I have
final.
used.
Yes.
My lord, mistakenly, because the statute is before your lordship. Whatever I
So
say,
every decree which is not final,
and liberty to
liberty
apply
to
shall
apply.
be implied. That was not done in the present case.
implied.
Implied. So that was not done in the present case.
Yes.
Because it is neither here nor there. So it
Yes.
does not cover this terms of settlement. On the contrary, terms of settlement itself fixed partly decree, but this is a part decree. It is not final. So if it is a final, that it has to be applied for. Implied, because it's a statute. Original side rules, my lord has legislated this original side rules. This is above CPC. Now, lordship kindly comes to Rule 22, page 169. Drawing and signing of courts or judges' orders. Every order of the court or a judge shall, upon application under Rule 27, be drawn up in the office of the register and be signed by the registrar or master. Rule 33, page 172. Where a variation is made by the court in the draft settled by the officer, such variation shall be embodied in the decree or order, and except where the cost of the application are ordered to be paid, no fresh order need to be drawn up. So, my lord, the variation that is made in the decree beyond the scope of the terms of settlement, that the suit has come up for final disposal, which is deviated from the terms of settlement, signed on 2008, while the defendant number 2 was alive on that date, but died subsequently. Now, thereafter, this decree has seen the light in 2014 for the first time. That too, as my lord was pleased to observe, just in the first half, that this decree was drawn up when it would be presumed on 4th February 2008. So this 4th February 2008 till 14th February 2014, while the collectorate engrossed the stamp ex parte without sending notice to under Rule 5 of the stamp rules to the defendant number 1, this period, how happened? After the order dated 24th August 2013, based on an application wherein defendant number 2 is shown alive, filed by the plaintiff, praying before the court, just like the execution case, that department may be directed to give the certified copy of the decree. Under the law, neither in the appellate side nor in the original side it is necessary. In the appellate side, registered administration is the authority. Within 3 p.m. to 4 p.m. we have to file a letter that we are not getting the certified copy. In the original side, registered original side has to be addressed. That was not done. Why it is not done? For the reason, because the defendant number 2 is shown alive. Now, if your lordship today is kind enough to call for the suit registry, I found that suit is still pending. There is no endorsement, but in the website of the Hon'ble Court, it is shown suit is disposed of. No date is given of the disposal. Who has done it? The department has done it. So, my lord, the disposal of this suit has created all problems. So, we have been ordered by the Honorable Division Bench on 5th September 19, we should be added. Now, my lord, as it is calling from my lord, whether these terms of decree, these terms of settlement is binding upon us. Now, if it is binding upon us, then we ought to have been added as substituted as party. Now, if my lord's observation order 22 rule 12 in execution case no substitution is necessary, the plaintiff has filed GA number 1855 of 2018 after demise of the plaintiff. The plaintiff has filed another GA number 1319 of 2019 after demise of defendant number 2, defendant number 1. But while filed the execution case, shown the defendant number 2 is alive. So in execution case, they choose, the plaintiff choose to file substitution for the plaintiff for the defendant number 1, but not in the suit, in the execution, which is not necessary as per order 22 rule 12. But today when we have been added with the present years, have been added as party without any adjudication, without any substitution application in this suit, fine, we are accepting it because we cannot go beyond it. It is hit by section 21 of the Limitation Act. Lordship kindly sees section 21 of the Limitation Act. Once. Already I have shown to your Lordship that deals with if any retrospective date is to be given of such substitution or addition, the court has to record it with reasons as to why it is given. That was not done either in order dated 21st June 2019 or in 19 July 2019 or in 4th September 2019 by the appeal court. Appeal court simply directed the plaintiff, you file an amendment application, you amend the cause title of the suit and the execution case. So we have been added, we have not been substituted in the suit. So if we are substituted in the suit in 2019 onwards, so the terms of settlement of the decree that is there and lost its force.
That is all dependent upon the fact whether the suit was still alive or is not alive.
Yes,
If
because
the
there is no
court- if
judicial
the-
order.
Just that's your contention.
Because
We'll
the
consider it. Whatever. We will also.
I have no order.
We are also as a court of record will look into the record.
Lordship.
So it all depends. Suppose
Lordship.
if the suit is found to be pending, then what you say substitution is required to be made. If there are two possibilities. If the court finds no, there was no suit alive after that, then there is no question of any substitution in the suit itself. You have also admitted this
Yes,
position.
because this is confirmed by
So
the
let
Honorable
us-
division bench.
Let us decide. Let us decide.
My-
We'll decide it. Then
Because this is already
any other. That's all.
Lordship, because for the first time, this Honorable Court is hearing me.
No, that's my, rather both of us always
See,
give the
last
fullest
14
of
years-
opportunity to the
Last
the
14
litigant
years,
to
I
argue.
didn't get this scope.
But
For the
I
first
think
time,
the
I'm grateful to
litigant
your
should
lordship.
also, the litigant
grateful
should
to your
also be aware of that they should not unnecessarily go on. They just put the point to the relevant points. The court will decide it.
Lordship,
At least that much expectation
my lord,
we have.
my lord, My lord, I'm
What is the
getting to
next
your
point?
lordship that-
What is the next point?
Yes. Now, my lordship kindly comes to the execution petition.
Again, what do you want to flag? We have seen
The
first,
GA number,
first page of this we have seen.
the GA number 2719 of 2009,
Yes,
filed by the plaintiff
yes,
on the self-same issue of execution case,
correct,
is still pending today.
correct,
By the order dated of the Honorable Division Bench 3rd May 2013
correct,
concerning the other properties.
correct.
Therein a receiver was appointed. That is still pending. That has not been disposed of
Correct.
because the order dated 25th January 2012 was challenged by the defendant number.
So according to you, by the impugned order, they could not have said that the entire execution proceeding is disposed of.
Lodge.
So
Grateful,
it
dear
should
Lord.
have been a part execution of a decree and the part it should remain alive so far as the other properties are
No,
concerned.
part execution of the decree so far concerning the other properties. My lord,
That would remain alive
my lord,
or that has been
My lord.
separately filed.
my lord,
I do not know.
my lord, I'm submitting, my lord. By the self-same terms of settlement, 4 properties were involved.
Whatever.
Now, one of the properties is the dwelling house of the parties.
Now it's
And-
the subject matter here,
Yes.
mainly.
Now, the issue is whether or not I say that I don't want to argue, I don't want to say, I don't want to submit anything concerning the other 3 properties. Perhaps I cannot escape the circumstances, but because of the reason of this section 21, because now today we are not under the law bound by the terms of settlement, so automatically all properties comes to us. So if all properties comes to us, so naturally, independently, I cannot say I have nothing to say about those properties. But if in future course, if the parties, all brothers, sisters are sitting together, what I have prayed before the court earlier, many of the time, so we can dispose of those properties by filing a fresh, my lord, the terms of settlement. Whether it is registered, whether it is unregistered, so we shall decide if they choose. Now the issue is, so for concerning this part, because we are residing jointly and every day's ins and outs, the administration of the property is involved. So, my lord, by the ex parte order, that has been prejudice, cause great prejudice to the, at least to me, whether or not the others.
So this point is that this impugned order is passed ex parte.
Ex parte.
Then
And listing
yes.
it as part when there is no judicial.
whatever.
Yes,
That's the next
Ex parte.
point.
My lord, the judgment I have shown. The other parts, my lord, so I'm not submitting because your lordship is only confining to the issue about this decree or final decree. So my lord, I should
No,
not
no,
waste
no,
your
no,
court's
no.
time, my lord, because that is already there on record in my written notes of submission.
That's all. Then we'll take care of.
So I'm not. Judgment already I filed on the very first date of 27 June 2023.
এই কোথায় আছে দিয়ে দাও তো
My lord, that is there in the execution petition at page number 99 and 100. That your lordship asking me in the morning. Page number 99 and 100 of the execution petitions.
These are the citations and where is his written argument?
প্রতীক ভট্টাচার্য দিন আমাকে আমি বলে দিচ্ছি আমার দুটো একরকম দেখতে perhaps this is mine, top one is mine perhaps.
Yes, you have given 2 copies, no difficulty, containing 150 pages.
Containing 150.
Yes, yeah,
These
that is on behalf of the appellant.
Yes.
No difficulty. Yes.
My lord, there are 63 issues I beg to submit, my lord. So since your lordship is having this, my lord, so I'm not.
No. We will. Don't worry. We'll take into account. Don't worry.
My lord, the judgment, my lord. Karukonda Chalapati Rao versus Karukonda Annapurna Sampat Kumar. The citation এটা reported আছে LL 2021 SC 530.
Yes,
The copy
decided
here.
on 1st October 2021. Don't worry.
Lordship?
This is decided on 1st October 2021 by a Supreme Court.
Yes.
And it's a reportable one. I don't know whether it has been reported. You can find out.
Yes, it is reported in LL 2021 SC 530.
Just AIR.
Not AIR.
Then?
LL. 2000, I have got from the website, my lord, this copy.
LL.
LL.
What is this LL?
My lord, the judgment copy, my lord, I'm giving.
No, we have a judgment
Yes.
copy with you, with us.
Lordship.
I'm saying this is delivered by Justice K.M. Joseph as his lordship.
Yes,
written was.
Lordship.
We have the copy.
Yes.
There is no difficulty.
Lordship.
But it does
I am
not appear
reporting
whether it is
para-
reported anywhere in the journal, either in SSC or anywhere. I did not find it. Anyhow,
My
we have
lord,
a copy
I
of
got
this
from the
judgment.
website, my lord, livelaw.in. From livelaw.in.
The live law will not do. Anyhow, yes.
My lord, I beg to refer to para 12.
Beg to refer para, we are
Para
just
12,
noting it. Paragraph 12, 14,
19,
19,
20, 19, my lord, I'm just giving the reference. Your lordship kindly comes to page 10 of the judgment. Para 12.
Page 10 does not contain paragraph 12, sir. It contains paragraph 26, 27, and 28 of this
My lord, this copy Xerox I have.
Karukonda. I do not know from
Karukonda.
where you got it. You have
Oh, lordship,
downloaded.
I have also got that copy.
Yes.
Yes. Para 12, it is at page 4.
Oh, yes.
Undoubtedly, lordship got it, my lord?
Yes.
Last part, last
Yes,
third part.
yes.
Undoubtedly, section 17(1)B makes other non-testamentary instruments which purport or operate to create, assign, limit, or extinguish, whether in present or in future, any right or interest, whether vested or contingent, of the value above value of rupees 100 and upwards. If an immovable property compulsorily registerable, section 17(1)C read as follows. 17(1)C non-testamentary instruments which acknowledge the receipt or payment of any consideration on account of creation, declaration, assignment, limitation, or extinction of any such right, title, or interest. And section 72 provides nothing in clauses B and C and subsection 1 applies inter alia to any instrument of partition made by the revenue officer. Section 49 of the Registration Act read as follows. 49. Effect of non-registration of documents required to be registered. No document required by section 17 or by provision of Transfer of Property Act to be registered shall affect any immovable property comprised therein, confer any power to adopt, be received as evidence of any transaction affecting such property or conferring such power unless it has been registered. 54. Provided that unregistered document affecting immovable property and required by this Act or Transfer of Property Act to be registered may be received as evidence or, of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act 1877 or as evidence of any collateral transaction not required to be effected by registered instrument. There is long line judgments of this court dealing with question as to whether family arrangement is compulsorily registerable. We need only to refer to the case of Kale versus.
Consider it. This very important because if it affects the rights, limits the rights,
Yes.
extinguishes the rights,
Yes.
curtail the rights, then in that event, affecting the immovable property or right in the immovable property, then the registration is compulsory under section 17.
Yes.
Now, the first question would be whether the terms of settlement is in the form of is in the nature of a family arrangement or it is something else.
Family arrangement.
No difference.
Family arrangement.
That is what you say. We have to decide. This is a
Lordship.
very larger question.
Lordship.
Yes, we'll decide. No doubt about it. If it is a family arrangement, compulsory registrable, no difficulty.
Yes.
You need not have to place. We are agreeing to the proposition.
My lord, thereafter, my lord, paragraph 3, 4 of that page
Yes,
5.
no difficulty, sir. We are agreeing with that.
But this judgment is totally dealing with the circumstances we are
Okay.
facing today.
Yes, we'll consider. No difficulties.
So, my lord, I'm not referring to any.
Not required. You have already referred. You need not have to just jump.
My lord, it was reported, my lord,
It is a reported. Just show us
2022-15,
just one. 2022-15
22-15, SCC 475.
475. Thank you. Take out this book. Don't worry.
My lord, the
Yes.
other one, I have given copy at that point of time. This is reported in AIR 57 Calcutta 375.
Yes.
Fact is a bit different in this case, but the principle I beg to submit that applies to our case.
Yes.
AIR 1957 Calcutta 375 equivalent to 61 CWN 553 in the case of Prabhat Kumar Mukherjee versus Shanti Ranjan Banerjee.
You have included
If not,
with
my lord, I'm giving my copy, my lord.
please give us 2 copies.
My
It is
lord, I'm
not
giving 2
included here
My lord, I'm
in the
giving 2
citation.
copies. My lord, perhaps it is in the last part of the judgment.
Yes.
If there is any pen mark, my lord, Rashikali, I don't know.
No, this. Anyhow.
The last part of the judgment, perhaps you not have the copy of me.
Yes. Yes. Next.
The next is, this is although concerning the criminal cases issues, but I'm relying on paragraph 8 and 9 of the judgment reported in AIR 2004 Supreme Court 1704 in the case of Union of India and others versus Mohanlal Likhumal Punjabi. Therein, the head note A deals with wrong concession made by a council cannot.
Oh, that is what is there. On a proposition of law is no concession, or on fact, no concession.
Why I submit so, my
No
lord?
difficulty.
Well, why I submit so, my lord? The advocate commissioner was informed by the defendant number 1 that these are the KMC law I would be facing. So kindly, then the commissioner held. I brought the report of the commissioner. The commissioner held that
Sir,
order of the court is required.
Sir, the commissioner's report has not been taken on record.
Yes. That is taken on record.
Or, sir, in the sense, as a part of the final decree.
Lordship.
It is on the basis of a terms of settlement which was filed by the parties.
Lordship.
Then we can definitely ignore the commissioner's report or something because it was not there. And the court appears to have passed either order or a decree in final form or no decree on the basis of terms of settlement. That's all. So we have to take note of that and consider whether it can be done. It's no question of concession.
Lordship.
Any other weapon in your armory?
My lord, the judgment of the Calcutta High Court I have given that.
Yes,
I'm
you have
relying on
given.
paragraph
You have
7.
given. Yes, you have given.
Paragraph 6 and 7.
Yes, you have given.
Yes. My lord, this judgment does not, the fact of the case absolutely different, but the principle of 50 subsection 2 of CPC, when can be made applicable, that is the Supreme Court judgment. This is unreported, this is reported 2024 INSC page 159.
INSC, what is this?
I don't know, my lord, I got from the website.
What?
Now, my lord, this deals with a promoter
2000.
failed to, I'm giving, my lord, 2024 INSC 159. My lord, I am handing over the copy. The fact
INSC
of the
kata?
case is absolutely different.
Sir, it may be, my brother is correct, neutral citation. It may be of that.
Maybe, my lord. Maybe. My lord, I'm
Yeah.
giving the copies.
Give that.
Only that this is a promoter who has, I'm giving copy to them. This is a promoter who has died, the developer. Now the purchaser, who are the purchaser of the flat, brought in the picture the heirs of the promoter, developer. The Supreme Court said no. The heirs are not the technical person. They cannot be brought on record. That is the principle. So therein, Lordship, I beg to refer, the fact is totally different, not applicable to us. But the paragraph 23, 24, only the principal logic I beg to submit. Paragraph 23, 24.
Yes.
Further, section 211 of the Code of Civil Procedure, for short CPC, defines a legal representative to mean a person who in law represent the estate of the deceased person, and includes any person who intermeddles with the estate of the deceased, and where a party sues or is sued in representative character, the person on whom the estate devolves on the death of the party or suing or sued. Thus, the legal representative of the deceased are liable only to the extent of the estate which they inherit. So, in this case, my lord, we inherit the property today as a whole after the order dated 4th September 2019. In the segregated course, we have not inherited the property because still we are living jointly. Of branches of Banco National Uttara Marino versus Nalini by Naki, AIR 1989, Supreme Court 1589, it was observed that the expression legal representative as defined in
Sir, we know. Right? Because it does not mean that only the heirs are to be included. The definition of a legal representative is wider in the sense that anybody who intermeddles with the state of the deceased are also regarded as the legal representatives. What was the
Now-
case here has to be
Yes,
considered.
that at
There's no
the beginning I
difficulty.
said, what I'm on is this today in our case, we whether have inherited only lot B or we have inherited the lot Schedule A property as a whole as equal one-fifth owner or one-eighth owner. That is the only question for
Yes,
that
yes.
reason I've shown.
No difficulty.
Because during their lifetime, they have not and could not and failed to demarcate the property and to report it to the court.
Yes.
Well, these are the judgments.
Thank you. Thank you.
My lord, may I
Continue
may I-
after races.
Yes.
I think you will not take much time to that.
My lord, I will.
You are for
I am for the plaintiff.
plaintiff and you are for
I am for the different number 2 series, my lord.
two cities. Are you opposing the execution?
No, my lord, I am
Yeah.
supporting the
Execution.
He has filed execution
And
after admission.
you are not taking a plea that you were not substituted.
No,
not
no. I am supporting the execution. It is only the defendant number 1 series who have been opposing the execution all through.
All through. And even they were espousing your cause as well.
That.
So
their
continue after 2 and the finish.
My lord, may I take my lord 5 minutes time, my lord. Few points I left out.
No, you have included in your written argument.
My lord, that is correct. My lord, this letter I discovered.
I think this is
Corporation-
a some kind of an appreciation should be done that we have given such a patient hearing.
Several exceptions are pending before the.
Whatever, we will see to it.
My lord, the remarks passed against me by my lord and my father. My lord, that
Who?
may be deleted. My lord's bench.
Which bench?
This bench, my lord.
This bench you never-
While hearing the appeal, interim orders were passed. Some remarks have been made against. me.
What against you?
Some remarks.
What
while
remark?
passed the order, my lord, in the order dated.
Yes.
6th October 2023.
No. We never made any remarks.
Said in the application also, my lord, to.
What remarks? What remarks?
My lord, I don't want to read in the open court.
6th October cannot be by this bench because this bench was not there.
Here on 5th of.
He was not there even after his
Because the matter
departure.
is decided over by my lord Justice Tandon. So for that reason, my lord, I read in the application. Yes.
And something which is not there on the record should not be taken and record.
I shall.
If there is an order, the order will speak by itself. We will see to it.
That's. My lord, I beg to appear for the plaintiff, my lord. If your lordships kindly takes, my lord, my list of dates I have filed.
Where is that?
By the plaintiff. Plaintiff respondent number 1. My lord, I have annexed all the relevant orders, my lord. That is why, my lord, it is voluminous, my lord. Kindly excuse me. My lord, it's my lord, page number 2 first. On 8th March, my lord, 2005, a preliminary decree was passed by consent of the parties. Then, my lord, a commissioner of partition, so appointed, my lord, filed a report before this honorable court. Then, my lord, in 2007, the parties have entered into a terms of settlement. A decree has been passed accordingly. In 2008, my lord, there are certain clauses, my lord, in the terms of settlement. As my lord, the plaintiff was under the terms of settlement, was my lord allotted, the defendant number 1, my lord, has allotted southwest tenanted portion. As per the commissioner's report, that southwest tenanted portion fell into the share of defendant number 1. The defendant number 1, as per the terms of settlement, was agreed to sell that part in favor of the plaintiff. I, my lord, made over a sum to the amount of 10 lakhs. In addition to that, my lord, I have also paid a sum amounting to 67,833 as a consideration money against Lot C to the defendant number 2. The constructions to be made in the part of the defendant number 1, that was Lot B of the premises, my lord, I have paid an wealthy money to the tune of 1,86,000, my lord. That is, my lord, in page number 3. After receiving all that consideration money, the defendant number 1 filed 2 applications. One, my lord, for appointment of receiver, that is, my lord, GA 1361, and my lord, an application for recalling the consent order, consent decree, my lord. That is 1493, GA 1493 of 2009. My lord, the matter was taken up by Honorable Justice Patharia. My lord, kindly takes page number 36. There is the order. Why, my lord, Justice Patharia, while, my lord, hearing the application, denied to grant any interim order in favor of defendant number 1. My lord, kindly takes page number 37 from the second line, first paragraph. I'm not reading the whole order. Page number 30, it starts from page number 36.
Yes.
Page number 37, my lord, second line. Except two conditions, all conditions have been complied with. The conditions which have not been complied with relate to extension of cooperation during construction and repair and shifting to the respective lots by the parties within the time specified. Liberty has been granted to each party to make necessary construction in allotted portion. The above mentioned clauses of the terms of settlement have not been acted upon, as without the signature of the other co-owners, no sanction will be granted to the petitioner for construction of kitchen, bathroom, water reservoir for the purpose of making Lot B a self-contained unit. Order 26, Rule 13 and 14 of the Code of Civil Procedure contemplates appointment of Commissioner of Partition to partition an immovable property. The procedure has been laid down in Rule 14. By virtue of such procedure laid down, the commissioner is to initially make an inquiry and thereafter divide the property into shares and allot such shares to the parties. The value of the shares can also be equalized by payment of wealthy money that my lord, I have already paid to. On the basis of the said shares allotted, a report is to be filed and no such report has been filed by the commissioner. There is no final report by the commissioner nor confirmed by this court. Therefore, the provision of Order 26, Rule 13 and 14 have not been complied with, nor has the commissioner has discharged by the terms of settlement. This was the minor arguments made by defendant number 1. The valuer surveyor appointed had also admitted that the legal factors in respect of the said premises was not scrutinized. Therefore, no reliance can be placed on the report of the valuer surveyor or the report of the commissioner, and the decree dated 19/12/2007 be recalled, as the terms therein cannot be worked out. Counsel for the legal heirs of the representative of the defendant number 2 submits that by a letter.
Have to argue, need not have to say, straight away come at 38 where the finding is.
Yes.
I think the terms of settlement on the basis of which the decree has been acted upon by the party,
Yes.
except in respect of
And the commissioner of partition need not have any occasion to go into the merit. Then, my lord, last paragraph of page number 38 is very relevant, my lord.
Yes.
Then, my lord, the matter was heard by Honorable Justice Banerjee. The order is at page number 44.
Same application.
Yes, same application.
Yes.
The order starts at page number 46, my lord, wherein, my lord, the Honorable Justice Banerjee directed the defendant number 1 to make an application before the Kolkata Municipal
I do
Corporation.
not understand, because page 39, please clarify. It says the opening sentence. Therefore, no interim order can be passed at this stage and directions are given for filing affidavits.
Yes.
Then why
Thereafter,
after
affidavit were filed, my lord.
why thereafter the interim order granted is extended for 10 weeks? Same page 39. If the first sentence is no interim order can be passed at this stage and directions are given for filing affidavits, then after the direction, why interim order is extended?
My lord, my lord, 15 June order, my lord, I do not have with me. My lord, the 15 June order, my lord, is not, my lord, I was not there, my lord, I do not know what has happened.
So these are the part of the court's record and you don't know what has happened. You have
This
participated.
order, my lord,
Anyhow.
There was to the extent that no
But-
parties would
Yeah.
with the others.
Then why the interim order should not be passed? Anyhow,
my lord,
then the same matter came up at page 40.
yes, 46.
46 or 40?
46. 40 is the same, and then, my lord, 46.
Yes.
My lord, on 27th August, my lord, the Honorable Justice Sanjeev Banerjee
It says
directed,
that make an application, defendant
Yes.
number 1, for sanction of the building relating to construction of on the proposed lot B within
Yes.
fortnight.
yes,
So this says, then
order is there, page number.
whatever need not, sir, you need not, sir, let him finish.
Order is
So this is the order which was
Yes.
there.
Then, my lord, defendant number 1 filed a recalling of the order that is
Of
appearing,
which order?
recalling of the earlier order.
Which order? Justice Patharia's order?
No, my lord, Justice Sanjeev Banerjee's order. Last
Which one?
order,
This is 27th August.
27th August.
Say that. Recalling of 27th order, August
Yes.
order.
On
Where is that?
My lord, it is at page number 51.
Yes.
This is an application in effect for modification of an order passed on 27th August 2010. The matters referred to herein include the prayer for considering section 178. My lord, the submission has been made before your lordship. The same submission of the Kolkata Municipal Corporation Act had been taken into account while passing the order dated such and such. In any event, the order dated such and such was made
Then
in a
GA
matter, made in a matter.
GA was dismissed.
This GA was dismissed, my lord, and
With these
appeal,
observations.
yes, an appeal was preferred, my lord.
Yes.
At page number 54. The appeal court, my lord, framed a timeline for submitting a plan, and my lord, construction were to be made within 3 months from the date of the order.
Yes. Then
My lord, page number 55 is very important. First 3 lines. Needless to mention that the earlier objection raised by the appellant defendant with regard to the mutation of lots allotted in favor of the other co-sharers could be deemed to be withdrawn. My learned friend is still agitating the same point that the mutation was done ex parte. That was not the case. In view of this order, my lord,
anyhow,
then, my lord, the interim application which were filed before Justice Patharia, which was heard by Justice Banerjee, was came up for hearing. In view of the appeal court's order, Justice Banerjee was pleased to dismiss both the application. At page number 59.
Yes.
May I read out?
Page number 59.
Yes. Page number 60, my lord, GA in respect of 2719, which was filed for appointment of appointing a special officer, was, my lord, liberty was given to the defendant number 1 to file afresh.
Yes.
An appeal was preferred from the said order. At page number 62. Having heard the learned counsel appearing for the parties, considering the facts and circumstances of the case, we dispose of this application by directing Kolkata Municipal Corporation authorities to complete the mutation proceeding, complete the mutation proceeding and provide SSC number to the different lot holders in compliance of compliance with the earlier order passed. Then, my lord, interim orders were passed in this APO number 423 of 2010. Orders, my lord, are appearing at page number 64 by the division bench.
The authorities have refused to take a necessary step for separation of the plot. This is lot B.
Yes.
And then appellant was not in a position to submit the plan. Then,
Yes. Then, my lord, on 28th June 2011, the
just 1 minute. So interim order was granted to maintain status quo. Then
Yes, yes. Then, my lord, the interim's order were passed at page number 70 in the said appeal, my lord. The status
Yes.
quo order was further extended,
yes.
and then, my lord, at page number 71, my lord, KMC refused.
No. It says only the separated by mutation and with definite boundary.
Yes.
So then,
My lord, the appeal was finally APO number 423 of 2010 was finally disposed of by an order dated by Honorable Justice Matre on 10th December 2012. Order starts at page number 80. The brief facts of the cases, my lord, are till paragraph 10, my lord, paragraph 11.
we have seen that.
Yes.
I have reached paragraph 13, 14. Don't worry.
My lord, in 14, my lord, all submissions which are made before your lordship. Re-agitated by my learned friend.
So that was dismissed. That was
Yes.
a review.
That, yes, that
Then-
was dismissed. My lord, confirming the decree. Confirming the decree,
On 4 occasions says that it is lawful or not, has set at rest, cannot be reopened. Then
yes, I'm grateful. Thereafter, my lord, since the appeals were pending, I could not obtain certified copy. So I filed an application for obtaining drawn up certified copy. The order your lordship will find at page number 101. I filed an application, the plaintiff, for obtaining certified copy. The order dated 24th September 2013. My lord, may I read out? The only prayer sought by the plaintiff herein is for issuance of the certified copy of the decree dated 19 December 2007. It is quite possible that the certified copy could not be issued as the proceeding had been initiated by the parties and were being contested.
yes,
all the
anyhow, it says that within a period of 1 week, you have to
Thereafter, my lord, I have filed the execution case after obtaining the certified copy
Certified
of the
copy.
decree.
yes.
Your lordship will find that the issue of maintainability was taken by the defendant number 1. The 3 issues which were taken by the defendant number 1, that the suit has been abated against defendant number 2. Certified copy has been, the decree which has been drawn up has been signed by a judge who has not elevated, my lord. Order 20, Rule 2, my lord, provisions comes in. And my lord, the third point was taken by the defendant number 1, that the decree could not be executed. They are not bound by the decree. My lord, an order was passed on 10 June 2014. My lord, order is at page number 105 by the executing court. My lord, whereby defendant number 1 was directed to share equal 1/3 share which the plaintiff has paid for obtaining the drawn up decree.
Because it has to be engrossed on a stamp paper.
Yes, yes, my lord, I'm grateful.
Then-
Then, my lord, by an order dated 10 July 2014, which is page number 107, the executing court direct the defendant number 1 to immediately pay the sum,
Then-
1/3 share.
Yes.
Both the orders, my lord, were challenged in an appeal before Justice Topenshen, Honorable Division Bench, presided over by Justice Topenshen. Page number 111 is the relevant order, my lord. May I read out? Heard the learned counsel for the parties, this is an application for stay of the operation of the orders dated 10/6/2014 and 10/7/2014.
Reasons have been given
Yes,
that all points can be raised therein and
yes,
that are being sought to be raised here where has already been considered in those applications.
yes.
Substitution leave is granted to take that point before
Before
the
the executing court,
Yes.
the said point was taken by filing a section 47 application
Yes.
before the executing court. My learned friend had indicated, my lord, at page number 118.
Yes.
The order passed in section 47. Page number, while dismissing the section 47 application,
This was he placed the
Yes.
full
Yes.
text of the order.
my lord, kindly takes
And
page number
ultimately it was
120.
dismissed.
Yes, kindly takes page number 120, re-EC 171 of
Correct.
2014.
Then thereafter the direction was passed in the execution proceeding.
Yes. According to this direction, my lord, the impaneled chartered engineer filed a report in the execution proceeding. It is at page number 122.
Practical solution of the problems. Then
Yes. It says, my lord, the construction can be made. The 4 construction can be made at 124 and 125 page number.
then
Then, my lord, the matter was heard by Honorable Justice Prasad. Honorable Justice Prasad, yes. Honorable Justice Prasad, my lord, while hearing my application, we filed an application for substitution because the original plaintiff number 1 died.
Yes.
For recording the heir, name of the heir of the
Yes.
plaintiff number 1. There, my lord, Honorable Justice Prasad directed to substitute the legal heir to bring the legal heir of plaintiff and the defendant number 2 on record.
The word used is the substitution.
Yes.
Yes, then.
Accordingly, my lord, page number 127. Accordingly, I direct the
yes.
substitution of legal heirs of the deceased defendant number 2, such and such, as prayed on behalf of the petitioner, Prosun Kumar Bhattacharya, Pratik Kumar Bhattacharya, and such and such.
Yes,
This
then
order was, my lord, carried into appeal.
this is a half order. There is another page, 127 after that. Nothing is given.
My lord, I'm sorry. I will hand over.
This is the half order.
I'm extremely sorry, my lord. So
Yes,
page
then-
has been missed, my lord.
Then
Then, my lord, the order was carried in appeal. My lord, order is at appeal court's order is at page number
says
128.
it is not a judgment within the meaning of
No, my
clause
lord.
15.
Page number 128. Yes. 15 of the letters patent, the High Court is a court of records. Keeping that view in mind, the trial judge has directed the amendment of the plaint as well as the tabular statement. That is the grievance, my lord, of my learned friend. He, my lord, sought to submit it before your lordship that by this order, my lord, the appeal court has confirmed that the suit is still pending in respect of the 4 properties. My lord, kindly see the observation made by the appeal court. Mr. Pratik Bhattacharya, appearing in person, has submitted that the order passed in such and such cannot be read as a final decree, since the first paragraph of the records there will be a decree in final form. The terms of settlement records that the parties have entered into a settlement and the suit is decreed in part partitioning the properties in Schedule A, B, C, and D. There cannot be any dispute that from a reading of the terms of settlement, insofar as the properties Schedule A, B, C, D are concerned, there is a decree in a final form.
Anyhow,
The final
it
form.
says that anyhow, this was not a subject matter, but since he has raised, so I am deciding it.
Yes.
Then it
It has
says
been
it is in a
decided
final
that decree
form.
is final between the parties in respect of
final
A,
form.
B, C, D
Yes, then-
properties. Then, my lord, the execution case was heard by Justice Kapoor. When the matter was transferred before Justice Kapoor, my lord, it was issue has been raised that the maintainability of Section 47 application maintainability of the execution application should be kept open. It was submitted before the honorable court that after dismissal of the Section 47 application, no question of maintainability is there. Then, my lord, I preferred an appeal from the order at page number 131.
Yes, I was a party to it.
Yes. My lord has dismissed my appeal, my lord. Therefrom, my lord, I filed an SLP at page number 133. The apex court, my lord, did not interfere, my lord. Given direction to the executing court to dispose of the execution application as early as possible.
Correct.
Then, my lord, this judgment has been passed. Judgment starts at, my lord, page number 134.
Page?
134.
Yes.
My lord, kindly, my learned friend has submitted.
This is what an impugned order is.
Yes.
Yes, no
At
difficulty.
page number 143, kindly, my lord, takes once. My learned friend has submitted the order. The judgment was passed ex parte. My lord, kindly see. Page number 143, paragraph 8.
Yes.
How this can be ex parte judgment?
Yes.
And my lord, at page number 140. On page number 159 is the direction passed by the executing court by directing the legal heirs, that is legal heirs of defendant number 1 series, that is defendant number 1A to 1C, to directed to execute the deed of conveyance
In
in
respect of,
respect of southwest tenanted portion of premises number 88/2 Rafi Ahmed Kidwai Road, Kolkata 13, and also to execute the deed of conveyance in respect of Lot B of Karshiang and Lot C of Ghum property, and to hand over the possession of the property of Lot A, respective properties in favor of the plaintiff within 8 weeks. This order, my lord, is challenged before your lordship in the present appeal.
yes,
My lord, I put this question to myself. This is one of the terms of settlement. What wrong the executing court has committed by directing the legal heirs of the defendant number 1 to execute a deed for which they have received, my lord, 10 lakhs rupees. They have, my lord, received in 2008 all the wealthy monies for making construction, for making their lot habitable. After receiving the money, one after another objection has been filed on behalf of the defendant number 1, original defendant number 1. My lord, the judgment of Dhurandhar Singh, my lord, Dhurandhar Prasad, my lord, under section
No.
40.
so you wanted to say that a person of that name could not succeed under section 47. Then he cannot move beyond that person.
My lord, being a legal representative of the deceased, my lord, who has originally filed a section 47, my lord, being a legal heir of the original defendant number 1 who has filed a section 47, which was dismissed, my lord. Now, my lord, they cannot sing on a different tune that we are not bound by the decree. As the agreement was entered into between by my father and my 2 uncles, my lord, that is not binding upon us. A legal representative, my lord, has to toe, my lord, the line of succession he is getting from his father. He cannot, my lord, turn back and resist a decree.
Yes.
My lord, that's all.
Yeah, may I, my lord? The final decree, subject to correction, was passed on 19 December 2007. I'm sorry, ma'am. The final decree was passed on 19 2007, my lord. The defendant number 2 died on 31st May 2008, my lord. So, my lord, at the time when the defendant number 2 died, the suit was already disposed of since a final decree has already been pronounced. What happened after that, my lord? We will kindly take up their stay application, that is GA1.
Yes, yes.
Mind you,
Substitution. They wanted to go for a substitution of the heirs and legal representative of the deceased plaintiff. Say substitution of the heirs of the defendant number 2.
page 72, my lord will kindly come to.
What do you want to say?
This part of the order was already placed by my learned friend. This is regarding the substitution in the plaint, which was affirmed by the honorable division bench, and in fact the honorable division bench has used the words decree finality, that the suit has attained finality. It is may I read out? My lord. It says, in respect of the said properties, this decree is final between the parties. This is the language used. It firstly says there is a decree in final form. Thereafter, it goes on to say, in respect of the said properties, the decree is final between the parties. So it is really a final decree. This has been specifically stated by a division bench. No SLP from this, for which this is binding upon the defendant number 1 series, my lord, as of today. But in my humble submission, the defendant number 1, the original defendant number 1, not these persons had filed an application under section 47. In that application, all these points were canvassed. But will kindly, the section 47 order is quoted in the impugned order. I'll show from the impugned order. It is quoted verbatim in the impugned order, for which may I show the, my lord, page 20 of the impugned order will, my lord, will kindly come to. May I read out? A decree was passed. This is the section 47 order, final order. A decree was passed on 19th December 2007. It was a compromise decree. It was for partition of premises number 88/2 capital A, Rafi Ahmed, Kidwai Road, Kolkata 7,13,000, along with other properties. An application for execution was taken up by the plaintiff for the execution of the decree. Another application under section 47 of the Code of Civil Procedure was filed by the defendant number 1, namely Pran Kumar Bhattacharya. In this execution application, various points have been taken on behalf of the defendants to challenge the decree. First, it was stated that it is not a final decree. This is the exact point what is urged today, but a preliminary or a part decree. Secondly, it was stated that the decree was inexecutable. It is submitted that the decree provided for division of premises into Lot A, Lot B, and Lot C. Lot B had fallen in the share of the defendant number 1. Lot B was not habitable. The decree provided for some constructions to be made. Therefore, unless those constructions were made according to the choice of the defendant number 1, the decree could not be executed. Mr. Bhattacharya, learned counsel, submitted that the portion which fell in the share of the defendant number 1 did not provide for bathroom, kitchen, staircase, etc. This is a submission. Other ancillary points were taken, namely that the decree was not drawn up according to the terms of settlement. The heirs of the defendant number 2 had not been substituted in the execution application, was not in proper form. All the points which have been urged today, my lord. As far as the substitution of the heirs of the defendant number 2 is concerned, this court noted that in an earlier order, that no substitution was required if a party died after the decree. It was carried in appeal. The appeal, I am told, was dismissed. As for the first ancillary point is concerned, I think it is of no substance. A certified copy of the decree is annexed to the execution application. Furthermore, a party to a compromise decree cannot, in my opinion, turn around and resist execution thereof. On the above technical point, there is a certified copy of the execution application. It was the obligation of the defendant number 1 to supply a certified copy thereof to facilitate execution. I have scrutinized the execution application and hold that it is in proper form. This is a specific finding, my lord. In my opinion, this matter has been unnecessarily prolonged for a considerable length of time before this court because of the resistance of the defendant number 1. It has also spent similar time before the Court of Appeal at the instance of the same party. The decree is a compromise decree for partition. The reference to the construction in this decree only refers to those constructions which would make each of the partitioned parts of the premises independent and capable of separate enjoyment. In my opinion, the decree does not provide for making substantial construction as the defendant number 1 has indicated in his proposed plan. Substantial construction may be carried out by any of the parties only after partition in terms of the decree, in my opinion. Furthermore, the import of the expression construction to be made in the premises was considered by the division bench of this court in its judgment and order dated 10th December 2012, where the division bench explained the following. The division bench order is quoted. We have noticed time and again the division bench of this court had passed orders to ensure that the parties to the compromise decree implement the terms of settlement without prejudice being caused to any of them. The division bench has directed the defendant number 1 to submit a plan so as to make lot B habitable. It appears, however, that the defendant number 1 submitted a plan which was for constructing a new building on lot B. And
He has already quoted, place that.
my lord,
Take a connection or to connect with the existing structure.
yes, he wants a separate building altogether.
You were only supposed to submit a plan relating to this toilets, staircase and all that.
My lord. So that plan never came. The plan which came was an extensive building in itself. So my lord, it comes most importantly, the defendant number 1 has received rupees 10 lakhs from the plaintiff for agreeing to take lot B under the decree. So once the defendant number 1 takes the fruits of the decree, but when it comes to my obligations, I will not execute. This is the stand of the defendant number 1 all along. Furthermore, he is entitled to further amounts at the OLT for having so agreed by signing the compromise and having acted upon it. The defendant number 1 is stopped from challenging the decree itself as inexecutable. I come to a conclusion that there is no
Dismissed ultimately.
Section 47 was completed. Appeal not filed. Not filed. This order has now reached its finality. So after that, nothing really remains. Nothing remains. Every point which was urged today was urged before the Section 47 court. The Section 47 court considered and rejected all of them. Today, what remains? Nothing remains. My lord.
My lord, may I give a short reply, my lord? Short reply, very short.
Not on facts.
Not on facts, on law.
They have not raised any issue of law.
But my lord, what they said that I was hurt,
Yes, he was hurt.
that
He
I
was
was hurt.
Yeah.
It lordship kindly say,
the order has been
recorded, making a rural and a written.
notes of submission, that was, but I was not hurt. Page
Hurt.
103, 148.
almost 6 pages of submissions.
That letter which you choose immediately on the next.
Yes.
These are all factual aspects.
No, my lord, what
I
I'm
have all those in my.
this is one part. The other part, he said that dismissal of section 47 automatically execution case survives. Suppose today,
He never says.
no. What I'm on is this: section 47 was dismissed. But does that mean that decree is in accordance with law? Man, that is my question.
The Section 47 court
Please,
held
sir,
that.
please, sir.
Held
You
that.
have, please, sir.
I'm
My
sorry.
lord, may I submit?
We will consider that.
My lord, why I am submitting so?
Let us.
Lord, I would be missing it, my lord. I would be missing it.
Understand. I'm
Lordship.
rephrasing your point.
Lordship.
In my own way.
Lordship.
I understand.
Lordship.
Wanted to say that section 47, there may be a certain issue which they are and have been discussed, but does not mean that the decree is a sanction of the law. The decree which either is not executed or a decree which is not a decree at all in the eye of law can still be gone into by the execution.
In addition, that part he has didn't submit. This particular part of the addition and or if it is named as substitution was done in 4919. That is after the decree was sought to be executed in 2014.
That has also reached it.
If the honorable division bench,
only proposition of law.
That I am submitting.
He has raised an issue on law that once an application under section 47 of the Code of Civil Procedure is rejected, having filed by your predecessor, cannot take any such plea which was taken in that section 47.
I'm not taking.
You say that you are not taking.
No, what I am submitting in the appeal of the plaintiff themselves, the honorable division bench deviated from the order passed in dismissing my execution because the division bench thought fit the parties to be added both in the execution case as well as in the suit. So that part I submitted in 2014 was accepted.
One function of mine, your lordship.
Who are you? madam?
I am one
Oh,
of
you are one of the
one of the
full blood brother of
the appellant. Lordship, just one small submission, Your Lordship, that I have filed an application before this executing court challenging the veracity of the decree on the ground that the decree has been obtained by fraud upon the court. Lordship, and I was only...
When the fraud was detected...
Lordship, the fraud was detected when this judgment was passed. I tell Your Lordship, this judgment. Lordship, in this judgment... Lordship, I am before the executing court.
You are not challenged this order?
Lordship, I am before the executing court.
And
I'm a respondent before Your Lordship.
only thing is that you have gone there, we will take care of that, that will be decided.
Your Lordship, only that much, Your Lordship, will kindly record my submission. Because Your Lordship, if it is... Because if it is not recorded, Your Lordship, I would be prejudiced. I tell Your Lordship, every time that matter is being heard, my learned friend's first claim is, Lordship, the appeal is pending.
Yes.
And Your Lordship, my claim before the court below is, the appeal is pending on the ground, the appeal is proceeding on the ground that there is a legal valid decree. Whether technically right or not right, that's a different thing. But I am before this court challenging the veracity of that decree. So, Lordship, every time this is taken up, Lordship will kindly record my submission. I'm grateful, Your Lordship. Lordship, because before Your Lordship, I'm not opening my brief. So I'm just making a submission, bringing it to Your Lordship's knowledge. Lordship, what has been submitted before the trial court? That this application is...
Also making certain observations.
Lordship, that the application is pending. That is all. The application is pending.
The second section 47 application
Lordship,
by the other end.
Where fraud is, Your Lordship knows the the Chinnaswamy case, Your Lordship. I believe it is that, I forget the name. Lordship, that judgment is there, followed by this Honorable Court and the Supreme Court on a number of occasions. Lordship, where there is a fraud upon the court, upon the court, Your Lordship. Lordship, this is not a fraud intercede the parties. If it was a fraud intercede the parties, Your Lordship, I would have never come up with this application. And if it falls from Your Lordship, I could also place it because I know Your Lordship's mind. Your Lordship would not throw me out of the court.
One sentence.
Your Lordship would not. Once I take Your Lordship to that, Your Lordship, but Lordship, the hearing is complete.
Make certain submissions, but one sentence is enough.
Your Lordship, but the matter is being heard.
One
It is
sentence
just the hearing is practically over. I have to only give my
No
reply,
need to say anything.
and Your Lordship will
So
kindly
are you
record my submission.
serious in inviting our attention to that fact?
Lordship, since the application is not, if Your Lordship
No, I'm
calls for
just
the
saying,
application, that's all.
Serious that you are inviting our attention.
Lordship, I have filed an application. It is being heard. And Your Lordship, all arguments are over. I have to only give my reply. So I would not be wasting Your Lordship's time further.
I appeared of the Kolkata Municipal Corporation as and whenever order has been.
Anyhow, as and when the order is passed, is not there, done, you are the really, I would say what actually I was not going to use the word of mischief monger, but you have created a lot of mess. You rejected the plan, took all sorts of objections, everything was done, and that really opens the entire Pandora box. Anyhow, you are a creature of an order, don't worry. You have done everything in terms of the orders.
Surely the last order which you should directed them to make an application under
Fair enough.
I filed an application to that. That is it.
That's all.
Grateful, Your Lordship.
These exhausted.
Mr. Advocate General had wanted second half because he said he's in difficulty in the first half, which
Naturally, it has spilled over to the second.
yes, so this we can he's here.
He's here.
Let's go.
Just something beyond the case. I find the use of iPad very frequent by all of you. More than welcome. Why are you not opting for e-filing?
But I think, Millard, the process is gradually, Millard, being put in place.
Why not? We bring a change.
Yes, it can be done. Like
When we have adopted this particular
yes.
thing, say the technology, advancement of the technology, and we are more.
This is one good thing that the COVID has given to us, at least to this profession.
Should have been taken forward.
Yes, yes, definitely.
Why is
Millard,
there
like,
a reluctance?
Not the iPad is equivalent to the notes we would make on sheets of paper.
Mhm.
But we need the feel of the brief. Without that, we will turn the
That
brief.
is what we require, a change in the mindset. Why you need a feel? Have a feel of the technology.
I need to it's easy. It's easier to
No, individual convenience has to be respected. I'm not talking about you as an individual. But I'm saying by and large, I see so many councils coming with iPads in most of the cases. But there is no such thing as e-filing.
now, like in Delhi High Court, I have seen judges may go paperless, but councils still carry them.
Therefore, I said individual convenience, how you are comfortable addressing the court is a different thing. institutionalization of e-filing. That is what I'm trying to.
That really will not affect the lawyers because we will still have our brief with us.
Correct.
So
Yeah.
it will be for the judges only who will have to go paperless. It
Hmm.
will be option for us. We can, we may not.
Both sides, it's an option.
But in fact, court number 1 in Supreme Court
Yeah.
doesn't allow anybody to carry briefs.
We all
Even
know
the
that.
judges don't have any paper. The court officers are paperless and counsels are made to be paperless. Unless you are a raw junior of say 2 months practice or 3 months practice. Ekdom.
Law juniors are more
The
tech-savvy
other
than
ones who are
anybody
tech
else.
savvy.
At the same time, they can read the brief and search a citation
Yes.
on the same equipment.
But now with that liquid text, there is a software liquid text.
I tell you then, let us take some other. Later.
thrice. Where, my lord, my
How long you will, because there is one administrative committee meeting, there's the committee meeting at 4.
but I need to, my lord, just a short recap. More or less, your lordship, it would come back to your lordship's mind, and then we'll have to place the judgments. That was what I was left with. I'll take about an hour, my lord.
To start, whatever, let us see. Next day, don't recapitulate.
My lord, please have a look to, my lord, the written notes of submission that, my lord, I had. Oh, दे दिया ना? हाँ. ये वाला, नहीं, मेरे पास ये सब क्या है? तुम्हारा जैसे तो नहीं दिखता है.
Sir,
Patient, a written notes, sir? Where are the
book. The volume
No.
is what
But I handed up my written notes.
pages.
Very true. नहीं क्या गड़बड़ कर रहा तुम ऐसी होगा. Only one copy is there. এটা আলাদা. This is what is with the court, not the one which you are having.
Yes, yes, you read it. Give us the plain white papers.
Extra copy है?
हाँ, copy से.
Not that one. Confused हो जाएगा. We have given to the court this one. तुम्हारे काছে তো এইটাই আছে. Too many written notes prepared. The last one, I think, which has been handed up to the court.
Probably every time when they go for a consultation, you prepare a
Yes, that's.
note of argument. Then
Yes.
they will do.
देखो.
Section 58.
मेरे पास सही तो है. तुम लोग का
ঠিক है. How could it be? কেন ওটা আমার সাথে লেখা আছে. ওনার নিশ্চয়ই তখন উনিও পড়ছে. Ask your junior, where is the second copy? AMDA is a dearth of money.
No.
They can't print out 2 or 3 pages.
But right now, it's not possible, my lord. But kindly permit us to, my lord. But I've taken it from Mr. Mitra, my lord. He has been very kind to, my lord, part with his copy.
Yes.
My lord, this is, my lord, in respect of a memorandum of understanding, if your lordships kindly recollect, my lord, KMDA was in search of, my lord, a joint venture partner.
Let me know.
Yes.
So we are aware.
Yes.
That there was, then there will be a consortium, and thereafter it will consist of these persons, and the modality that will also be.
Yes. And we have a joint venture company is to be incorporated.
They
Form
will have certain shares, they will have certain.
50 for, my lord, KMDA, 50 for, my lord, the consortium. Then, my lord, together Milord, then Milord, the joint venture was incorporated, and finally, Milord, the disputes have arisen. But if your lordships may kind,
Money was kept and they wanted the return of those money.
yes. Now, if your lordships may kindly take me to page number 2, paragraph number 4, my points. JVCO was incorporated on 9th May. JVCO is a separate legal entity
We
which,
have already raised
yes,
this issue that is a legal entity can sue or be sued, not by in the name of this person.
yes. And whatever are the claims of Mr. Mitro's client, those,
Everything has to go to JVCO.
right,
That is what you said.
right. But this is mere one of my points. Then if your lordships may kindly turn the page, point number or paragraph number 5, where I had already argued that here, Milord, Mr. Mitro's client had terminated the agreement because of so-called lapses on the part of the KMD. Where my submission is, Milord, going by the clauses of the MOA, where there is no scope of any termination. The clause says, or the MOU says, that if in case of a default by one of the shareholders, the non-defaulting shareholder will buy the shares of the defaulting.
You also said.
Yes. That's why I said only a short recap. This was my second point. Third where the third point is, paragraph number 6 over here, that whatever money the Mr.
Loan, because they paid money,
Right.
this was treated as a loan to the JVCO.
Yes, and it is shown in the books of accounts of the JVCO as loan. Therefore, if they want to get back the money, they have to sue the JVCO and take the money from them. Then, Milord, the next point is made on the claim itself, that, Milord, the claimant did not prove the other claim, that is rupees 62.33 crores, no lakhs, I'm sorry, which, Milord, was allegedly spent by them. And, Milord, we have also raised the point that the disputes were not arbitrable in the absence of, Milord, the JVCO. And finally, Milord, the constituents of the consortium could not have invoked the arbitration clause. But these are, Milord, the fundamental points, Milord, on which, Milord, I have addressed your lordships. But I am left with, Milord, citing the judgments, Milord, in support of my, Milord, submissions. My first limb of argument was that, going by, Milord, the judgment of the learned single judge, Milord, your lordships would find, Milord, that in case of many of the points, the Honorable Single Judge has held that since you have not raised these points before the learned tribunal, therefore you cannot raise these points over here. On that, Milord, my submission is, Milord, if an issue goes to the root of the matter, Milord, I can raise those points at any stage. Which means that if it goes to the root of the jurisdiction of the body or, Milord, adjudicator, Milord, then, Milord, it can be raised at any stage and even in a collateral proceeding. Well, this was, Milord, my first limb of submission. But if your lordships may kindly, Milord, apropos this point, have a look to, Milord, 2021, volume 14, Supreme Court cases, page 548. ठीक है, दुटो दिए ना, जॉब दे दिया. अच्छा, give me the page number over there. इसमें कितना पढ़ना? Milord, page 183, Milord, in the compilation.
By Cox and King, this is a group of companies theory.
Yes, yes. But this is because of, Milord, my point that the partners of the constituents of the consortium could not have invoked the arbitration clause. That is my last point. I'll come to that.
This has been referred to a larger bench. Has it been decided?
No, this one is the larger bench.
Cox and King.
Yes.
So the Fluoro Controls was the concept of group of companies within a particular arbitration.
Yes, yes, my lord.
Yes.
Something has been control view affirmed
Affirmed by the Cox and King.
by judgment.
Yes.
Now, if your lordships may kindly, my lord, have a look to, my lord, paragraph 13 and 14 of this judgment.
Serial number with judgment.
Where serial number 4, page 183 of the judgment compilation.
183 is
183.
MP Power Trading Company, Narmada Equipments.
Yes,
You want to refer this judgment?
yes.
Oh, no.
No. This is Narmada, Chief General Manager, Madhya Pradesh Power Trading Company.
Oh, that is what I say. Narmada Equipments.
Achha. But please have a look to paragraph 13.
Tara?
13, 1-3.
Yes.
We refer now to the second argument raised on behalf of the respondent that the appellant cannot raise an objection relying upon section so-and-so of the Act in the second application filed by it under section 11.6 of the 96 Act, when it had not raised the same objection in the first application under section 11.6 of the Act or before the arbitrator so appointed. It is pertinent to note that this argument was rejected by the single judge of the High Court in the impugned judgment and order dated in the following terms. I will be failing in my duty if the basic objection raised by Sri Manoj Dubey about maintainability of this application is not dealt with. Merely because in earlier round of litigation, the objection of maintainability was not taken, it will not preclude the other side to raise such objection if it goes to the root of the matter. It is tried law that jurisdiction cannot be assumed by consent of the parties. If a statute does not provide jurisdiction to entertain an application petition, the petition cannot be entertained for any reason whatsoever. Thus, I am not inclined to hold that since for the reason that in the earlier round of litigation, parties reached to a consensus for appointment of arbitrator, this application is also maintainable. I deem it proper to examine whether, because of operation of section 174, the present application under the Act of 96 is not maintainable. A similar issue was raised before a 3-judge bench of this court in Hindustan Zinc, where an arbitrator was appointed by the State Electricity Commission under section 86 of the Act with consent of the parties. Subsequently, the arbitral tribunal was challenged under section 34 of the 96 Act before a commercial court, and the commercial court's decision was challenged in an appeal under section 37 of the 96 Act, where it was held that the State Electricity Commission had no jurisdiction to appoint the arbitrator, since section 86(1)(f) refers to disputes only between the licensees and the generating companies and not licensees and consumers. When the matter could not have been raised in a proceeding under section 37 of the Act, once the parties has consented to arbitration earlier. Speaking for the court, Rohington F. Nariman J. held that
It says these are the principles borrowed from Ligard versus Bull of the English judge.
yes,
So it says that by consent of parties or by any other mode, the jurisdiction of the fora or the jurisdiction of the court cannot be conferred.
by consent you cannot confer jurisdiction.
That
Yes.
is what it says.
Yes,
So there is a distinction. If it is so far as the courts are concerned, if it is in relation to territorial or pecuniary, those can be waived.
yes.
But it is a
Subject matter.
inherently lacking jurisdiction in relation to subject matter that cannot be undermined.
Correct. This is the point.
And what about the arbitration? It's a private fora chosen by the parties.
Yes.
Where they control the proceedings.
There also, my lord, if it is not, what should I say, my lord, if it is not contemplated from the agreement, then also, my lord, parties by consent cannot give. For example, my lord,
For the case where the dispute relates to something else, which does not come within that particular purview.
yes,
The court has says that this appointment by them itself is without jurisdiction.
yes. Now, the fundamental point, my lord, on which I rely on this judgment or part of this judgment is that if an issue of jurisdiction was not raised
Can be raised if it strikes at the
root. Right. This is the point on which I rely upon this. Yes. Now, this judgment I have relied because this arose out of an arbitration. That's why. But under the CPC, it is well settled. Only one citation. I don't want to multiply. That is, 2012. Volume 4, Supreme Court cases 307. Which is at page 192 of my lord's bunch.
Kanwar Singh Saini.
No, this is Kanwar Singh Saini.
What I say?
Oh, acha, you have. Acha. Acha, acha. We're at 22 of this judgment. We're at 206 in the compilation. Only to put it on record. These are well settled principles just to cite a judgment.
Bear in mind the Rasmi metallic judgment of the Supreme Court.
Yes, not to multiply. That's why one on arbitration, the other on the general law.
Yes.
Paragraph 22.
22. There can be no dispute regarding the settled legal proposition that conferment of jurisdiction is a legislative function and it can neither be conferred with the consent of the parties nor by a superior court, and if the court passes orders degree having no jurisdiction over the matter, it would amount to a nullity as the matter goes to the root of the cause. Such an issue can be raised at any belated stage of the proceeding, including in appeal or execution. The finding of a court or tribunal becomes irrelevant and unenforceable, inexecutable once the forum is found to have no jurisdiction, acquiescence, etc. But just only to But these are, on the issue of jurisdiction, whether, if I have not raised, whether I am precluded from raising it or not. But the next one is, which is most important, is that the relief that has been granted. What is the relief granted? Pay back the money.
Cannot be granted.
My respectful submission is, a tribunal which is a creature of a contract can grant only those reliefs which may emanate from the contract, not something which is beyond the contract. Here, the only relief that could have been granted by the tribunal was that you buy the shares or you sell the shares on me.
What you say?
Yes, yes. On that, please have a look to 2006, volume 4, Supreme Court cases, page 445. Page 250 of the compilation.
Relied upon in a letter judgment. Hindustan was relied upon in a letter.
But I think the first judgment that I've cited, yes.
We have cited this MP power tradition.
Yeah. In that it is like
Page 200.
250. Relevant para 14 ta kothay dekho. But para 14 at page 256. This court in Saw Pipes has made it clear that it is open to the court to consider whether the award is against the specific terms of the contract, and if so, interfere with it on the ground that it is patently illegal and opposed to the public policy of India.
Yes.
Therefore, my lord, the tribunal, my lord, was at the time of granting the reliefs ought to have, my lord, confined itself to the terms of the contract. Well, it in fact not applies everywhere. Even a 226 court cannot pass a divorce decree.
Very big question.
It applies everywhere. Differently, my lord, with equals, a 323A tribunal cannot pass orders which a 323B tribunal can pass. Therefore, my lord, the reliefs in a private forum like this, the reliefs which can be found out from the contract itself, that can be, my lord, granted. But there is no equity jurisdiction. There is no inherent jurisdiction. And even, my lord, the courts under section 34, 36, 37, they are also, my lord, they also, my lord, cannot exercise equity jurisdiction. The only equity is, my lord, as I was saying on the last occasion, section 28, subsection 2. That too by when the parties agree to confer this jurisdiction. Otherwise, my lord, there is no equity, there is no inherent power. But in fact, my lord, if your lordships compare the 1940 Act with the 1996 Act, your lordships would find, my lord, one section missing in the 96 Act, which was there in the 1940 Act. 1940 Act, I think section 40 or 41, made the entire CPC applicable to court. 41. But the 96 Act, in the 96 Act, my lord, that provision is missing.
Talk about that. It simply says contain the provision that so far as the arbitral tribunal is concerned, they will not be guided by the provisions of the Code of Civil Procedure or the Evidence Act. Because of the party autonomy is the important factor
Right.
in 1996 Act.
Right.
So if the parties have decided, if they decide that yes, the entire proceeding would be guided by a CPC or a curial law as we call it, CPC and the evidence, then there's no difficulty. The arbitral tribunal will be bound by that. So it's a party autonomy.
Right.
They decide, they decide.
Right. Even the party can confer jurisdiction of the on the tribunal to pass an award without reason. That is also, my lord, contemplated.
What?
Without reason, an award without, yes. Parties can confer this jurisdiction on the tribunal.
1940, it was not mandatory to give reasons. But in 1997, there's some department. And the reason being that in 1940, the award has to be made a rule of the court.
Yes.
Here, it protects a character of a decree under the Code of Civil Procedure straight away. So reasons are to be provided ordinarily.
Well, please have a look at section 31, 3A.
Yes.
Of the 96 Act. Therefore, parties, as your lordships were, my lord, observing, that here the party autonomy is what is recognized.
That's why I'm saying that previously 1940 as very, I would say, radical switchover has really come. Maybe ancestral is the reason for this. UN Charter ratifying a state, we have to go uniformly with the other countries so far as arbitrations are concerned. So all these things have been brought so that it has to make it more robust and more foolproof, less interfere.
Yes. That is the purpose, right?
Find the last one.
Yes, yes. Less interfere. That is why, my lord, your lordships cannot be invited to review the claims on merits.
Even to interpret a contract. That's the domain of the arbitral tribunal. If they have interpreted, those words are the last words.
A possible interpretation has to be accepted.
Obviously. Something which is a patently, that's why the word perversity was introduced by way of an amendment. Something which is absolutely not there and which has been brought, so it comes within the purview of the perversity. You have to
Very well. Next Monday.
Why?
Tomorrow, I won't be here in this.
Actually, you have seen the earlier matter because I have seen this being dragged on since the ages.
Day only. Tomorrow, I've got some difficulty in the second half. Wednesday, Thursday, whichever day is convenient to the
Wednesday,
second half.
second half. ये कल के applications पूर्व से